At this time, prior to calling the roll, Eve Maxwell, who's got her back to you all, the Executive Director of the Real Estate Commission, will read a notice into the record and then call the roll. Please, Ms. Maxwell.
This meeting's date, time, and location have been noticed on the Tennessee Real Estate Commission's website, included as a part of this year's meeting calendar since August the 9th of 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Real Estate Commission's website since Thursday, September the 4th, 2014. This meeting has been noticed on the 10.gov website since Friday, September the 5th, 2014. Now I'll call the roll. Diane Hills. Here. John Grease.
Here.
Wendell Alexander. Absent. Janet DeChara.
Here.
Marcia Franks. Here. Austin McMullen.
Here.
Gary Bloom.
Here.
Grover Collins.
Thank you, Ms. Maxwell. At this time, I'd ask Commissioner Austin McMullen to lead us in the invocation, please. And when he's finished, if you'll stand, we'll say the pledge to the flag. Mr. McMullen.
Will you pray with me? Heavenly Father, we thank you for this day that you've given us and these lives that you have entrusted to us. Help us to use them in a way that would bring glory and honor to you. We thank you for this nation, for the prosperity that you've given to us. We pray that you would be with the actions of this board, grant each member wisdom, that in all things your will would be done. In your holy name we pray. Amen.
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Commissioner. All right, next up is to adopt the agenda. Are there additions or changes that any member of the Commission would like to make?
Motion to approve.
Thank you, Mr. Collins.
Second.
The motion by Mr. Collins is seconded by Commissioner McMullen to approve the agenda as prepared. All those in favor of the motion, please vote aye.
Aye.
Those opposed, no. Motion passes unanimously. All right, next up is approval of our last month's meeting's minutes. Any corrections or additions?
Motion to approve.
Second.
Motion by Commissioner Collins, seconded by Commissioner Franks. These minutes be approved as prepared. Any discussion? Let's vote. All in favor of the motion say aye. Aye. Those opposed, no. Motion passes unanimously. Ms. Maxwell, informal appearances.
Yes, first I wanted to introduce our new auditor.
Perfect.
That's okay.
Perfect.
Ahmad Lewis. There he is in the back.
Come on up, Ahmad.
Front. I sent you all his resume just so you'd know a little bit about his background. And he just started on Monday, so he's really, really new and spent most of Monday with HR in training. So he's, but he's going to be a great addition. We've already talked about some ideas he's got for the audits that we're mailing out, and I'll let him tell you a little bit about his background, and it doesn't move
Just pull the
much.
microphone down toward you.
Oh.
You have to lean way in.
Yeah, I see that. Got to lean way forward here. As Eve said, my name's Ahmad Lewis. Happy to be here auditing for the Real Estate Commission. And anything you all want to know, that'd be easier. I mean,
Where are you from?
from Minnesota originally. Yeah.
Welcome to the Eat.
Thanks. Appreciate you guys having me here at the meeting and allowing me to introduce myself. Yeah.
You know you're not going to be well liked, right?
Oh, I'm used to that at this point.
Okay, as long as you're aware of the fact they're not going to like you very much up there.
He's had experience working for the Minnesota Department of Revenue. So
I saw that.
Yeah, accustomed to not being the most popular guy around.
Worked for the Minnesota Department of Revenue for 7 years, and came to Tennessee and worked for DHS as an internal auditor, and now I'm here auditing for you all. So, but I am used to not being liked out there in the field, and that's okay. But I'm a likable guy, and I tend to turn people's attitudes around if they do have that. So,
Well, we welcome you and hope you'll call on us because we're pretty knowledgeable of our specific markets, and if we can help you in any way, we'd like to do that as well.
I appreciate that and look forward to developing relationships with all of you, in time. So thanks a lot.
Going to stay all day and listen to this, or you got stuff to do?
I do have stuff to do, but I just wanted to come down here and meet you all, and for you all to meet me and see me. So, yes.
Welcome aboard.
Thank you.
Thanks for stopping by. I will also tell members of the audience that other staff people in attendance today include, next to Eve Maxwell, Julie Kropp, who is our legal counsel. And she's uncomfortable today, apparently. I'm not sure why. And Kimberly Smith is in the back, in the very back corner. If you have questions or concerns, I hope you'll feel free to ask any of the staff or any of us questions during the day.
Betsy's back there, too.
Who's back there?
Betsy.
Betsy is the one who checks you in. Make sure you sign out. Make sure you do what you're told as far as that goes to get the credit that you came here to get. I think only other announcement I want to mention, we're normally a board of 9 people, 7 licensees, 2 public members. Today we have 7 people here, 6 licensees, and our public member is Attorney Austin McMullen, who's seated right over here. The rest of us make a living like you do, but during these meetings we turn our phones off and we don't play words with friends or anything up here, and we don't need you guys doing that as well. So if you would, your attendance will be appreciated. One more announcement. This is scheduled to be a 2-day meeting. You'll be disappointed to know that tomorrow's meeting has been canceled because a judge couldn't appear. So if you have hotel reservations for tonight, please, if you want to, don't stay in that hotel tonight. Go home. But we can't tell you with any certainty when we'll be done today. So don't have an expectation that at 4 o'clock you can leave, or 4:30 or 5 or 3:30. When we're done, you can leave. Any questions about that? All right, informal appearances. Ms. Maxwell?
Yes, the first informal appearance is a request for a waiver of the 50-mile rule, and the principal broker involved is Bobby Powers, and the affiliate broker is Dennis David Pritchard, and he goes by David, and the broker appearing on behalf of the national headquarters, who's also a licensed principal broker of one of their branches in Tennessee, Jeff Evans. And I think they're all here from, so you all have done this before.
Come on up, man.
If you can come up to the front, that would be great. And those of you who've been on the commission for a little bit have seen Mr. Evans and Mr. Pritchard previously, probably 2 previous occasions, I believe, requesting a waiver of the 50-mile rule. I sent some information on Monday about their request. I'll read just a little bit of information about the individuals. As I say, the principal broker who's making this request is Bobby J. Powers. His office is located in Lexington, Tennessee, which is 84 miles from the affiliate broker who he would like to have join his firm. David Pritchard lives in Cordova, Tennessee, and that's 84 miles as the crow flies, which is what the rule, the 50-mile rule requires, is that you measure as the crow flies. The broker who's appearing on behalf of the national headquarters office is Jeffrey Evans, and he is licensed in Tennessee. And Whitetail Properties Real Estate LLC is the firm. They have a firm office in Lexington that Mr. Powers is the principal broker of. They have a firm office located in Cookeville, which is where Mr. Wakefield, who was here at the last meeting, is the principal broker. And then Mr. Evans is the principal broker of another office that they have licensed in Tennessee, but it's located in Illinois, in Pittsville, Illinois. Mr. Powers is the PB of Whitetail Properties Real Estate LLC, which holds Tennessee firm license 262775 and is located at 3024 Black Bottom Road, Lexington, Tennessee. Affiliate broker Dennis David Pritchard, license number 328527, resides at 7740 Antler Cove West in Cordova, Tennessee. The distance between the Lexington, Tennessee offices of Whitetail Properties Real Estate LLC and the residence of Mr. Pritchard is 84 miles. and you all had the map attached. Mr. Powers was first licensed as an affiliate broker in Tennessee in 1975. He became a broker in 1995 and served as a principal broker from 1995 to 2000 and from 2001 until 2006, at which time Mr. Powers retired his broker license. In 2006, Mr. Powers went to work for the Tennessee Department of Transportation as a right-of-way agent. In his position as a right-of-way agent for TDOT, Mr. Powers, among other duties, was responsible for negotiating with private landowners on behalf of the state of Tennessee for the acquisition of land for public roads and infrastructure projects. Mr. Powers also served as the local public agency coordinator for West Tennessee in the capacity of advising local municipalities and individual counties in the process of buying rights-of-ways for their public initiatives and infrastructure projects. Mr. Powers brought his broker license out of retirement on 7/21/14 when he became the principal broker of the Lexington, Tennessee location of the licensed firm office of Whitetail Properties Real Estate, LLC. At the present time, Mr. Powers is the only licensee affiliated with the firm. It has no affiliates and no other brokers. According to the track records, Mr. Powers has no complaints filed against him and no formal disciplinary action. Davis Dennis Pritchard was first licensed as an affiliate broker in Tennessee on 1/30/2014. He placed his license in initial retirement while he sought approval from the Commission to affiliate with Whitetail Properties Real Estate, LLC. Mr. Pritchard and Mr. Evans first appeared before the Commission in June 2013 seeking a waiver of the 50-mile rule for Mr. Pritchard to affiliate with the Pittsville, Illinois office of Whitetail Properties Real Estate, LLC, Tennessee license number 262247. Jeff Evans is the PB of that firm location. At that time, the Commission denied the request based upon its determination that Jeff Evans, the principal broker of the Pittsfield location of Whitetail Properties, while licensed in Tennessee, was a non-resident, the firm office in Illinois was too far away for adequate supervision, and Mr. Pritchard was not yet licensed as an affiliate broker in Tennessee. In an effort to move forward in Tennessee, Mr. Pritchard became licensed as an affiliate broker on 1/30/2014. On 9/19/2014, Whitetail Properties selected a qualified individual to become the PB of the firm's Cookeville office. And Mr. Evans, Mr. Pritchard, and that particular PB appeared in March of 2014 before the Commission to request a waiver of the 50-mile rule. The Cookeville location was over 200 miles from Mr. Pritchard's residence, and the Commission determined that that was too great a distance for adequate supervision and denied the request for waiver. Whitetail Properties has continued its efforts to establish and operate a firm office in Tennessee with which Mr. Pritchard could affiliate. After a diligent search, Whitetail Properties found Mr. Powers, a principal broker who has the experience and depth of knowledge to represent Whitetail Properties and supervise, mentor, and teach Mr. Pritchard. Mr. Pritchard has been a highly respected wildlife biologist and forester for over 20 years and is the owner of Wildlife and Timber Resources, LLC, a company which is involved in assisting its clients in the overall management of their land and natural resources. Mr. Pritchard's firm currently has clients located in 8 states throughout the Mid-South and Midwest. Mr. Pritchard has a master's degree in forestry and wildlife from Mississippi State University. While the waiver of the 50-mile rule is pursued, Mr. Pritchard has continued to run and operate his business, and his license remains in retirement but can be activated upon submitting a completed Truck 1 form identifying a firm and a principal broker. Mr. Evans has submitted lengthy request letters for the appearances in June of 2013 and February of 2014, and I've included excerpts from the February 2014 letter which describe the business model of Whitetail. Whitetail Properties is headquartered in Pittsville, Illinois, and specializes in selling hunting, recreational, and farm properties exclusively. The firm does not list and sell homes unless the homes are on a larger hunting, recreational, or farm property which the firm has listed. The firm has brokerages in 19 states and has over 120 agents licensed with the brokerage throughout those states. The business model of the firm is structured such that agents work in specific territories and are hand-selected based not only on their professional experience, but also on their ethics, integrity, and passion for the outdoors. The firm utilizes technology to teach, coach, mentor, and supervise agents throughout the office locations. The firm has 3 full-time brokers in the main office in Pittsfield who are there every day to assist teach, and educate the agents, and to review their documents and transactions. Every agent goes through an intensive 2-day orientation at the main office in Illinois, designed to make sure that the agents know the applicable laws, procedures, the firm expectations, and who to contact if they have questions or concerns. Every other Thursday, the firm has a mandatory webinar which addresses current areas of concern and topics which impact the real estate market. During the webinars, all participants can interact with one another on a live screen, real-time interface. The firm is finalizing the completion of an enterprise resource planning tool which will enable them to more closely monitor each transaction between every customer, client, and agent. This system should help ensure that all customers and clients are adequately protected in and satisfied with their interactions and transactions with Whitetail Properties Real Estate LLC agents. The PB of each licensed firm is likewise charged with the ongoing responsibility of teaching, mentoring, and supervising any affiliated licensees in their firm. Mr. Powers has stated that he is and will be actively involved in the daily operations of the firm and will be actively involved in mentoring and training Mr. Pritchard. And now I'll...
Thank you, Ms. Maxwell. Let's, just so everybody knows who the players are, Dennis Pritchard.
David Pritchard.
David Pritchard,
Yes, sir.
thank you. You would like to place your now retired license with Bobby Powers, right here.
Bobby Powers, yes, sir.
And Jeff Evans is a national guy who's, you two have been persistent, if nothing else. I guess we'll start with you, Mr. Powers. Are you,
Pull that microphone.
anything you'd like to say that wasn't in that statement?
Just the microphone tilts down toward you.
Oh, okay, there we go. Pardon my ignorance.
No. Anything you'd like to add to the statement that Ms. Maxwell read?
Well, I will say that I've studied the situation about where David lives, and he's down in the Cordova area, and, you know, they're kind of down in the corner there, you know, and if you look, they've got like a vortex, and so
The microphone.
you take their, you know, you strike that arc, and he doesn't really have a lot of area there to find a broker in the area that he likes to do, like working with land and hunting and recreational properties. And I've looked at the maps real carefully, and I found that, you know, we're talking straight down I-40. So he and I can meet most anywhere. His a lot of his property is in like Fayette and Hardeman County, much further east. And I'm familiar with all of West Tennessee. I worked in West Tennessee, bought right away all over West Tennessee, from Memphis all the way to the river, from Paris all the way down to Bolivar in that area. So I'm very familiar with his territory, and I personally don't have any problem taking him on as an affiliate broker. I've studied it and thought about it, and I wanted to tell the truth about it. I don't see any problems whatsoever, and due to the nature of our business, you know, we would appreciate you granting us just a few more miles.
Mr. Collins?
You have your broker's license. Somebody had to bring theirs out of retirement. Was that you or who?
I brought my broker's license out of retirement.
Okay.
Yes, to go to work for Whitetail.
Okay.
Which is my primary interest as well, is hunting land and farmland and that type of thing. They were a perfect fit for me.
Chairman,
Collins?
I'd like to make a motion we approve.
I'll second that.
I have a motion by Commissioner Collins, seconded by Commissioner DeCharo, that this application for waiver of the 50-mile rule be approved. Is there discussion?
I have a question.
Commissioner Bloom?
Yes. Mr. Powers, are you still working with TDOT?
No, sir. I retired with TDOT 5 years ago.
Okay, and since 2006, which I think according to your testimony is the
Okay,
last
I'm sorry.
time.
That date somebody made a mistake on.
Give me that microphone up there.
I'm sorry. That's one mistake that was on our paperwork I didn't notice. I went to work for TDOT in October of 2003, and I had 6 years with TDOT credited time, which added to my teaching time and Vietnam era service time, allowed me to have a little retirement and keep my insurance. My wife and I bought a 20-foot RV. We traveled every state in the Union except Alaska. It was hard to get to Hawaii in that, but, you know, we did. Not in that, though.
So from 2009 to 2014, what's been your involvement in listing or selling property?
Okay. During that time, I only dealt with I have some rental property, and I only dealt with my personal property. I did some development work And I have been involved with the real estate business all during that time. That's how I earned my income, is through rentals and development.
So how familiar are you with what you're going to be teaching Mr. Pritchard about
Would
real
you
estate?
please repeat? Would you
Well,
please repeat?
you haven't been involved in real estate for 5 years, except your own personal property.
For the last 5 years, yes, sir, that's
All
right.
So, but now you're striking out to provide principal broker training for Mr. Pritchard.
That's correct.
I'm just seeing a big gap there.
Well, there is a gap, but I've been involved in real estate. If you take my personal out of it, over all of the years before that, and I've got a lot of experience supervising affiliate brokers, and I'd like you, sir, to take a look at my record. And of all those affiliate brokers I've supervised, and there's been several, I don't want to quote a number, but there were several, and we never had a problem we couldn't work out. And I can't recall one of my affiliate brokers ever been written up by the commission, and we've had several times that we've been audited. I believe Mr. Donnie, I don't know if Donnie's still there or not, but he certainly did a fine job. He'd go through those records really careful, and we've always been in order. And I tried to check all my affiliate brokers' records, and we'll certainly do that now. We're computerized, and everything will be there on the computer. As he sends in these listings, I'll be with him as needed, meet him at his property as needed, and we'll go through everything that has to be done. I've read through the rules in the last few months really carefully, tried to get changes and all that. And I can meet him at his office. I go to Memphis regularly. I go to that area. I've got a son who lives in Midtown. I go to the Veterans Hospital occasionally. I'm in and out of Memphis. You just buzz down there and back without a problem. It's not much more than living in Jackson as far as I'm concerned. It's easy. It's an easy drive down there.
Thank you.
Other questions?
Yes, I'd like to ask, I'm interested in knowing, are you as a broker grandfathered?
Yes.
And when was the last time that you took a real estate class?
I took a real estate class about, when was that last webinar? Do you remember, Jill?
I'm talking about that you got TREC credit for.
Oh, through the TREC?
Mm-hmm.
I'd have to check my record. It's on the computer, I think, but I can't tell you that time, that date.
Has it been in the last 5 years?
No, only through Whitetail, broker training through Whitetail Properties. And that was a webinar that we brokers across the country all participated in, and I satisfactorily finished that.
Since he's been licensed, I don't know when I didn't write down when he took the last course, but since he's been licensed, he has 297 total hours of education.
And what is the specific, you said there was a specific territory. Where is that?
We're all assigned territories. Currently, I'm just Henderson County, as far as I'm concerned, but he's going to have Hardeman County and Fayette County and, Shelby, I suppose.
All of Southwest Tennessee.
Yeah.
So what's, okay. And now, so you are not the gentleman who lived in Cookeville then? They got
No, ma'am.
another broker?
I live in Lexington, Henderson County.
Okay.
Just north of there, between there and I-40.
So I'll ask you, sir, is there some reason that you didn't get someone within the 50-mile radius? Since you've been here, this is your third time, and you obviously know what the rule is?
Yes, ma'am. I mean, for us, it's not about just finding a person within 50 miles. I mean,
Even though that's the law?
Yes, ma'am. I understand. You got to understand. We've been a year and a half in this search. And finding a qualified broker that is interested in our business and what we do. It's not easy. We've ran multiple ads throughout the state of Tennessee in various publications, and we were very fortunate that Mr. Powers saw that ad and contacted us. So our search has not been to bend the law or bend the rule. We've just had to work within the ability that what we've got.
Well, I'll just say I don't have a problem with either of these two men. I'm sure they probably are qualified. But it just kind of bothers me that this is the third time that we've seen you in here, and you keep bringing in different principal brokers, and none of them have been within the 50-mile. So I'll just say that I'll have to vote no on this.
At one point in the commission's history, we didn't apply the 50-mile rule for probably 2 or 3 years, and that's where I'm coming from. And with the modern day of technology, I think it's kind of an archaic rule, personally. And our MLS for Middle Tennessee goes from one end of the top of Middle Tennessee to the bottom of Middle Tennessee, and we sell property in the whole area, and that's just all I have to say about it.
Well, and I'd like to speak to it too, because they are from my area. I am a member personally of 2 associations, of Jackson Association as well as Memphis Association, and I have agents in a lot of outlying areas because the choices for brokers are not real plentiful to get a broker that you connect with, and the kind of business they're going to be doing is farmland and recreational land and large tracts of land. I would say in Shelby County, there's not a lot of brokers that have a lot of experience with land. So I understand having to go to a more rural area to find somebody that's qualified to work with somebody on land. And I do appreciate you hanging in there, and I do appreciate y'all continuing to try to do what we've directed you to do.
Are there other comments? So in my mind, the question is about 34 miles, not 50 miles. If 50 is okay in a case like this, is an additional 34 miles connected by an interstate a big deal, especially if the technology is
And you know, I can approve up to through 75 miles administratively, because the commission's given me the ability to do that. So
we're talking about 9 miles. So is this something that maybe we need to, as a commission, look at? Is this, if this is archaic, I mean, why do we have this rule if we don't enforce the rule?
The legislatures.
So that was who made the rule? It's a law, not a rule.
It's a rule, I think.
It's a rule.
We can take a look at that rule if you'd like, Ms. Franks.
I would like for us to do that, because you know, it's hard for me. I'm pretty black and white with laws and rules and things, because I try to follow those. But if we're not going to enforce them, and I see what you're saying, that I know every month there's fewer and fewer people even applying for it to be a broker in the state of Tennessee. So it's a huge responsibility. So if this commission is willing for us to talk about this and maybe changing that distance, then I would feel better about it.
And the rule as it is written, Commissioner Franks, does specifically allow for the commission to consider a waiver when circumstances are. I can read the subsection. I mean, the rule as written doesn't just say 50 miles, and these gentlemen aren't just in here asking to waive for that. There is a provision where someone can request a waiver, and that waiver can be granted within the same rules. Yeah. So.
Okay.
I would amend Ms. Frank's motion to substitute out that rule with a rule that prohibits the chairman's phone from going off during the meeting. And I withdraw the motion.
I'd impeach the dang chairman. I've got a little telephone learning disability.
You got a new phone, I think.
No, it's an old phone. I still can't get it right.
I hope the rest of you do not have the same problem.
So I don't think Ms. Franks put a motion on the floor, so I don't think Commissioner McMullen can second or amend it at this point.
Well,
sorry to be out of order.
I'd like to make a motion.
Can we vote on it?
Okay, you seconded it.
No, I did.
No. Oh, okay.
Now, if there is a motion, if you'd like to offer a substitute motion, or we'll take up a new motion after this vote.
That's what I'd like to do.
Okay. All right, is there other discussion on the motion, which is to approve the waiver of the 50-mile limit? I hear no other discussion. Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no.
No.
The vote passes 6 ayes, 1 no. Commissioner Bloom votes no. Jeff, will you keep coming to Nashville, or what?
Sir, I was telling my colleagues here this morning, I've pretty well got this trip down now. So I love Nashville, so if I need to come back, yes, sir, I will.
Well, we hope you don't have to come back, and we especially don't want Bobby Powers to come back. Yes, sir.
I'll tell you what, Since you've been coming down, you look more pleasant and happier, and I think it's been good for you.
It has. I appreciate that. Thank you.
Well, good luck to you all, and
Thank you.
Thank you very much.
Appreciate your consideration. Thank you.
Okay, so I'm trying to decide what the motion should be.
you want to add something to next month's agenda for consideration?
Yes, why don't we add it to next month's agenda? Okay, I make a motion that we add to next month's,
We can do it without a motion.
we can do it without a motion,
If-
okay.
If you request it, we'll put it on there.
That we discuss the 50-mile rule. That's good.
Can I make a motion?
Yes,
I
Mr.
make a motion, we do away with the 50-mile rule.
It's a rule, we'd have to go through a process.
I'm not, we haven't done that while I've been here. I'd have to check into that, but I can do that when we discuss next month and kind of let you know what the process would be, what our alternatives are, if you want me to look into that in the meantime.
I'll second his motion,
Well,
so we can talk about it.
we can.
I move to continue the motion to the next meeting.
I'll second that. Okay.
Yeah, there are some, we've seen some examples. We'll talk about it next month. Do we have another informal appearance at this time, Ms. Maxwell?
We don't have another informal appearance until 10:30, but Rachel Powers, who's the Program and Policy Development Director, I don't know if she was going to come at 9:45 and answer questions about the online resource, formerly known as the manual. And so she's not here yet because it's a little early. But I can tell you a couple of things in the meantime.
I would
if you'd
love
like
for
me
you to do that. You tell us what you want to tell us.
Okay. The commission last month, when the broker from Keller Williams was here, Ms. Fran Hooten, had said that they wanted her an audit conducted on her business, and until we got an auditor who could go out there and do that, we did send her a principal broker audit, our mail-in audit form. We haven't gotten it returned yet, but it was delivered to her on August the 18th. So she hopefully will fill that out and answer some of the questions, at least that the commission raised last month when she was in here with her informal applicant. So we'll keep you updated on that, but just to let you know that that's been done.
Does that mail-in audit suggest they get it back to us within a certain number of days?
Yes, it does. It says they have 30 days from the date of the letter to get it back to us, and it was sent on August the 15th. So she has just another week or another 5 days or so to get it back. And we haven't heard from her. This is just from the information from the United States Postal Service tracking site. Do you want me to just go through some of the little updates that aren't going to take very long? Okay, I can do that. I can just do an update of the fingerprint update. I'll just sort of do some things that won't take that long. The fingerprint update, just to let you know how many fingerprints we've had. As of 8/31/2014, we've had 2,813 individuals fingerprinted. 549 have come back. Their reports show that they had some interaction with the law enforcement officials one way or the other. Of those 20%, that's 20% of all the reports that we've gotten. 2,200 came back with no indication, and 64 all told have had no read on their prints, and they've had to have them done again. The last month for August, we had 314 total prints taken, and of those, 261 had no indication and 48 had an indication. And of those that have indications, as we've mentioned before, which means they have some set of incidences on their database that comes back. About 30% of those do not have dispositions of the incidents that are listed. So we then have to go back to the applicant and ask them to get either court disposition paperwork or write a short, if it's just something like a DUI, to write a short summary of what happened. Sometimes the charges would have already been taken off, or they never became a conviction. And in some cases, there might have been an expungement, but those aren't showing up on the report that we get back. So we have to clear any questions that we have that are about the report. So that, that can sometimes take some time for the individual to get paperwork back to us. And that seems to be, since we do have to clear those questions that we have about any incidents, that can take some additional time. Did you say Rachel was here? So I think Ms. Powers has just walked in.
Could I ask one thing? Something has come to my attention in the last few days. Someone told me that they're aware of a realtor who has had a DUI, and they have one of those breathalyzer things to start their car. We don't have any kind of rules or anything about people with no licenses. I don't know how we would ever police that, but that really disturbed me to hear somebody's driving customers around blowing into a breathalyzer.
We don't have any, these are all people who are applicants, so that they're not currently
Right.
licensed. And if you're currently licensed, then there is a section of 6213.312 that would allow the commission to revoke a license if someone hasn't reported within 60 days of a conviction of a felony or a misdemeanor that primarily involves the theft of money, services, or property. And if they report it, then it just goes through the complaint process. There's another section of 312 that would provide for us to file a complaint against a person, but I don't know that crime would be deemed one that would fall under.
And I don't even know that that's what Commissioner Franks is asking. What she was saying is, would there be a way to have some kind of rule or something saying that licensees had to have a license? And I'm
Right.
not sure about that. I'd have to check into it. I mean, it would definitely require at least a rule, and I'm not even sure if, considering the circumstances of, I guess everybody, there would have to be, I guess, some kind of guarantee that people that couldn't get it for other reasons, weren't prohibited unfairly from getting a license. So there could be potential problems that I could look into it, but we certainly don't have anything like that at this point. So.
And we have some blind people who are licensed.
Right. So I think the issue with requiring a license and then maybe some people not being able to get them for reasons such as that, we might run into some problems with that. But it might be something to consider if we could address it from a different maybe angle. I mean, it's something for thought.
Hours. Would you do us a favor today and sit up here where people can see you from both directions? Thank you. Ms. Maxwell, what's the topic?
The topic is, Ms. Powers is here. She's the most knowledgeable about the online resource, which was currently known as the manual. And she's here to answer questions that you all had about it and about the time frame, the RFP, or any questions that you all have about what was formerly known as the manual, which is now, I don't know, I call it the online resource. I'm not sure what.
Can you turn it off, Diane?
I know, give it till me turns off for you, John. What kind of phone does he have? He's got a
You can't turn it off, I can tell you that.
Their defense means you pay
For lunch, right?
Yeah.
My fault.
Good point.
So anyway, so that's why Ms. Powers came, because last month you all said that you wanted, like either Ms. Powers or Deputy Commissioner Giannini to come and just update you on that and tell you a little about it, answer any questions that you might have more specifically than what I was able to tell you last month.
So what is the status, I guess? Yeah, that would be my question, too.
Oh, absolutely. There's currently an RFP out where it's open for bids, and that process is the same RFP process for every state contract, and the deadline to submit bids is October the 10th. So at that point, we should have all the interested parties in with their bids, and then there will be a review committee that's put together to review all those bids.
And so we're only looking at it being online, right? Not this.
Well, the online resource is supposed to be, and the idea is that it be very user-friendly, and it will have a button where you can, like a lot of legal resources have, a printer-friendly version where you could just hit that button and the printer-friendly version comes up and it's easily printable. or an email version where you could email it electronically as well.
So the RFP is for a tech person then, right?
Not for an individual person, it's for an application.
So after the bids are let, what's your anticipation of the time for we could go to a computer and find this information?
The contract signature deadline is November the 3rd, and that's listed in the RFP as well. And our expected date for it to be working is, I believe, up to negotiations by the department, but I'm expecting the latest as being January 1.
Will this have like a search button? For instance, if you don't know where to look in this book, if you were to just put in advertising, would it bring up everything about advertising, or would it still just be pages that you need to look through?
Well, that's the idea, that, for example, if you're looking for licensing, then you'll have a licensing subsection and it's going to list all the licensing.
Right.
Does that make sense?
Yeah,
so it's a
right.
lot more user-friendly than having to go to your PDF of the rules and looking at the top where it says and then scrolling to page 45, which isn't listed at the top, it's just done by section. Does that make sense?
Yes. That's great.
Well, this will have the sections of the Tennessee Code and the rules in it? Okay.
It'll be combined.
Okay.
And how easily can it be updated?
The updated piece is in the contract, and it's supposed to be updated within 30 days of the changes.
This, Ms. Maxwell, is this, I remember we had a representative, was it from Lexus, who was here? What did we end up deciding about that?
We ended up deciding that the commission had agreed with the price that she had given us at final price, but wanted the approval of the administration. And at that point, the administration was just getting into conversations about having an online resource and really wanted that online presence. And if you recall, LexisNexis was a little bit ambivalent about the online. They would just 2 years ago, they just started getting into it in 2013, and in the end of 2013, they still were not geared up to really do that, and the cost to the licensee was going to be $35 to $36 with a $9 rebate for shipping and handling. And at one point they had said they would give a rebate back to the state, but we couldn't. That's not something the state could not do. And so as it turned out, the administration got involved in discussions about this particular type of resource, and that for the whole department, for all of the regulatory boards, and so that's kind of what happened to it. And I think LexisNexis, you anticipate they'll be one of the bidders. I'm taking LexisNexis.
I don't have the bidding information.
I just wondered if you
Right,
thought they probably would be one of the.
I would expect that
Yeah.
they would be, since this is a resource that.
Ms. Powers, you gave a couple dates that I need you to repeat again.
Absolutely.
There's an October date.
Yes, the deadline for responses for the interested parties is October the 10th of 2014.
Okay.
And then the contract signature deadline is November the 3rd of 2014.
Okay, now, is this all regulatory boards or just for the Real Estate Commission?
It's all programs. So each different program, if you've ever been out on our website, you see all the regulatory boards. Each board, it lists their laws and rules out there, so it would be the same resource for each different program.
And active the 1st of 2015.
As long as we get bids and someone accepts.
Will this online resource be available to everybody, or will you have to have a password and pay something to get in?
It'll be available to everybody. It's for the public and for the licensees.
Other questions? We appreciate the update. Thanks for coming down.
No problem. If you have any future questions, feel free. I am easily accessible.
Thank you. Thank you.
Eve, when did you say that next informal appearance is?
10:30. But I can do the education report if you would like, and the reinstatement request, if that, get those. I wasn't sure how long any of these would take, so it's always sort of, when I'm trying to schedule the individuals to come in. Would you like me to do the reinstatement request?
Yes.
Or, okay. I've sent you some information about the reinstatement request, which is by letter, and I noted in the little write-up that I sent to you all that the person making the request is James Larry Crawford, and he has Tennessee license number 205409. And he requested that the commission reconsider his reinstatement penalties and grant him a waiver of the penalties and the meeting attendance requirement. Mr. Crawford and his principal broker, Robert L. Bobby Sane, license number 204902, were prepared to come to the commission, but they live in Bolivar, and I advised them to submit a written request initially in lieu of driving in from Bolivar. Mr. Crawford's affiliate broker real estate license was in an active status when it expired on 9/22 of 2013. Mr. Crawford was first issued an affiliate license on 10/17 of 1979. Mr. Crawford stated that he did not receive a renewal notice and that his firm, Bolivar Insurance and Real Estate Agency, Inc., number 54304, principal broker Robert L. Sane, did not receive a renewal notice regarding Mr. Crawford's renewal either. The track records indicate that on 6/24/2013, a renewal notice was sent to Mr. Crawford at his home address of record as of that time and to his firm address of record. None of the mailings were returned to TREC by the United States Postal Service, and since state mail is not forwarded, the mail which is not delivered is returned to us. And when we receive the mail back at TREC, we log it in, and if there's a forwarding address, we put it in another envelope and send it back out with a TREC 1 form to change the address. And if there's not a forwarding address, then we make a copy of the envelope that it came back in and put it in the person's file. And we make a note in their file and on a larger Excel spreadsheet that we have as well. Neither one of these pieces of mail were returned. Then Mr. Crawford's license was suspended on July the 1st of 2013 for failure to provide proof of E&O. Those notice of suspension letters were sent to these same two addresses. Neither of those came back, but 12 days after that letter went out, Mr. Crawford called us and sent in proof of E&O and was removed from suspension. So he did get those letters last year. The TREC files indicate that Mr. Crawford's home address of record with TREC at the time of the renewal notice was 131 Cedar Hill Drive, Waverly, Tennessee. The TREC records indicate that this has been his home address of record since 7/10 of 94 and only recently changed on 8/8 of 2014 when he requested his home address be changed to Marion Creekmore in Bolivar, Tennessee. Mr. Crawford, as you all noticed, did include a reinstatement letter that was dated April 12, 1995, addressed to his Marion Creekmore address, but we have no record of a request by Mr. Crawford to change his address to Creekmore, and there's no record that mail that was sent there to the Cedar Hill address wasn't returned. As you know, TREC is not required by statute or by rule to send out renewal notices, but we do send out courtesy reminder notices 3 months prior to the licensee's expiration date. The reinstatement policy would have required Mr. Crawford to pay a penalty of $1,250 plus the $80 renewal fee for a total of $1,330. His license has been expired for 320 days. That's from 9/22 of 2013 until he contacted our office on 8/8 of 2014. As I say, he is requesting a waiver. He wrote a letter that says, "Dear Commissioners, I'm asking for your consideration in waiving the civil penalty on reinstatement of my real estate license and the requirement to attend the commission meeting. I understand it's my responsibility to keep my license current, but ask that you consider granting a reinstatement due to the fact that the renewal notice was mailed to the Waverly address. I moved from Waverly 22 years ago and have been getting my notices at my current address in Bolivar until the last renewal. As I've stated in the other correspondence, Mr. Sane and our bank have had issues with mail delivery and hope that you will take that into consideration in your review of my request. I have not been active in the real estate business but plan to retire soon and have made plans to move in that direction and make a portion of retirement income. I regret this error and the complications that this has created for all concerned. I appreciate your assistance in this matter." Larry Crawford, and his Principal broker, Mr. Sane, likewise wrote a letter, which I've sent to you all as well, that says that he didn't receive any renewal notice at the firm address either. And I can read that, or you all probably have already read that letter. So, as I say, what Mr. Crawford is requesting is a waiver of his reinstatement fees, some or a portion of his reinstatement fees, and attendance at the meeting.
Did receive the request to update his E&O insurance at the Waverly address?
Well, I mean, it was sent there, all I know is that in 7/13, 7/1 of 13, when those went out, they went out to the same addresses of record as the renewal notices did, and he responded to that within 12 days. Your assumption would be that he got it because he did respond to that within 12 days and sent in his proof of insurance. And he was, his suspension was removed. It's just that he did react to that, or appeared to react to that piece of
I'd move
information.
to deny his request.
Second.
You've heard a motion by Commissioner Bloom, seconded by Commissioner Collins, that this request be denied. The chair would
question?
opine that if we don't have a motion at all, it would fail on its own.
Can I ask a question? If this motion is successful, would he just have to go ahead and pay the fee and attend the meeting, and he would be reinstated at that point?
Yes, because I told him, even though the reinstatement's, for 12 months, the policy provides that, since he was in the process of, of trying to appeal it, as it were, that he could continue that, that process, whether it was he chose to come in, or, I guess he could come in if he, chose to do that, or just pay it, whichever he chose to do after a decision. I just told him I would tell him what the decision was, and he could.
And where is Bolivar?
It's,
Can't get there from here.
isn't it by Memphis? It's up.
It's
That's on Highway
outside of
64.
Nashville.
Yeah.
Oh, I thought it was
Nashville,
outside of
outside of
Jackson.
That's
Jackson.
what I thought, yeah.
Maybe about 20 minutes from Jackson.
Yeah.
Does the policy that you stated, does it just provide for the calculation of the amount that you stated, or does it also state about having to attend a meeting?
It also, it requires that if, under the terms of the reinstatement policy, it provides for that calculation that you see that I did, and then you sign a reinstatement order, and you attend a full meeting of the commission. But you have to do all of those things as a condition precedent to reinstatement.
My comment on the matter is, his broker made the comment that, and I guess I relate to this a little bit more because I had the same situation in my old office. Because Trek has a physical location on record, and that's where the mail goes to, sometimes the post office returns it because he has a post office box, not necessarily mail delivered at his residence or at his office.
His mailing, we actually have a mailing address and a business address for every firm.
And what does he, that was my question.
And his mailing address is actually 800 West Market Street in Bolivar. But we do have two addresses. If you have two, it lists a mailing and a business address, and the mailing is the mail, where the mail goes. And I understand he talks about a post office box, but we have his address is 800 West Market for the firm and for Mr. Sane and for Mr. Crawford.
That was my question after he made that comment. Because I know how they sometimes will deliver them and sometimes they don't.
Right, yeah. And that happens kind of all the way around, I think.
Are there
A
other
requirement that a licensee inform the commission of a change of address?
Yes, there is a requirement of that. And as I say, we only send the renewal notices out as a courtesy. We're not required to do that. Under the statute, we aren't required to do that. But yes, they are required to tell us that.
And not only should this person be watching those dates, renewal dates, but also his principal broker should have been also.
Call for the question.
I've got a motion to call for the question. Is there any objection to the call? I hear none. Let's vote. The motion is to deny the request. Those in favor vote aye. Aye. Those opposed, no. Motion passes unanimously. Thank you, Ms. Maxwell. Let's take one more item and we'll take a break.
Okay. Well, I'll just do the course renewals because that won't, that's just kind of an update. This kind of update of the course renewals as of 9/10 of 2014. Our total education providers when we sent out renewal notices was 173. The providers who have renewed their courses, we've had 94, which is 56% of our providers. Our courses that were up for renewal, 1,398. 969 courses have been renewed, which is a 70% renewal rate, and 222 instructors have been renewed. The fees we've received so far for courses and instructors is $30,775. Most of the large providers have renewed. At this point, we have a couple. MAR is due in the next couple of days. They had been remodeling, and we're going to send theirs in. And then Chattanooga is due in this week as well. Those will wrap up, and D&D. Those will wrap up the biggest schools that we have. Other than that, our biggest providers are in. And as I noted in this little write-up, we send out the renewals. But unless you want to advertise for the coming year and go ahead and set your schedule and start your advertisement, there's not like a penalty or a disadvantage for not renewing the courses. You can always reapply next year, and that would be fine too. So our renewal rate's not always 100%. As a matter of fact, it probably usually hovers between 60 and 70%. So, it's not that it's this unusual this year for the courses to, people not jumping up and renewing them. But a couple of years, in 2008, it was at 50%, so at the end of the year. So we are having more courses renewed. And I did send you all that information that sort of explained how the process worked for courses getting submitted and approved and presented to the commission and then approved. If you have any questions on that, I'd be glad to answer them, because I know sometimes it does get a little confusing the way we have these providers and then the people who give the courses and the way the providers are set up as well. But hopefully that answered some of the questions that you all had from the last meeting. So,
Ms. Maxwell,
yes.
if course content that's submitted is contrary to statute or rules of this commission, how do you handle that?
Well, you mean like if it's just like totally contrary to our rules?
Well,
like, so is the one that you all got?
Yeah, let's say that, for instance.
That's one that presented information that while it's not something that's recognized, teams are not recognized in Tennessee, it is something that is going on. And so, it was a course that has content. It's up for you all for discussion today, certainly, to discuss whether or not you all think that's something. There's actually another course, likewise, that discusses teams. And so that's for you all, for the commission to determine whether you think that should be something that should be taught or not taught in Tennessee. I guess kind of like reverse mortgages.
Whether we like it or not, there are teams everywhere across the United States. Sometimes I feel like we're, confusing this a little bit. The principal broker is always responsible. I think there does need to be education about it so that everybody that joins a team knows what the rules are, and not only them, but the principal brokers. But, it's a fact. And at NAR, I was looking at some of their classes to take at their convention in November, and there's classes about teams. So I think if there's going to be teams, I don't think we want to say no more teams, you can't have a team. But if there are going to be teams, I think everybody needs to be very aware that the bottom line is still that the principal broker is in charge. So if people need education on that, and it seems they do, then I think that we should allow education on it.
Well, my question was more general terms. If we get a CRS class that comes in and asks for approval, it may need to be modified to some extent, I would think, depending on what this state statutorily says has to happen or our rules are.
Right, I mean, and if it, yeah, right, I mean, if it had something that was totally contrary to what our rules say, then we would, like, we'd write them back and tell them that they would have to change it, much like if you got a timeshare public offering statement that didn't comply with our rules. But there's some topics that are, like, the teams are sort of a general topic that, it's up, as I say, that's why they're presented to the commission. And anytime any of the commission members would like to look at a course, I mean, I really would encourage you to do that so that, you know, you all have a feel for what is being taught out there, and so that, you know what the licensees are being exposed to in the courses. And we ask for more information if it comes in. I mean, I do if it comes in with just like an outline or something, just like a brief outline where you really can't tell what's going to be taught, or even just a PowerPoint that's not very informative, so that you can really get a feel for what is going to be taught in the course, and make sure that it's at least that I know enough information to have some information about it to give to the commission.
So it's typically, just like the course that you sent me, this big thick packet, I thought, is someone going over every word of this? I know that the education director probably was responsible for that before, but I mean, it was a lot of pages for anybody to look at just for this one course. So are you having to do that, Eve, yourself, or do you have someone on staff?
I read those.
Okay.
I mean, they sent, I think they have 2 or 3 courses this time. I mean, I read through those. Theirs are some of the better, more comprehensive course materials that we do get, but I read over those.
Commissioner Hills.
And I read over that. Thank you. That was very useful. And there was a small disclaimer. If your state, it was a very small disclaimer before you got into the body.
Yeah.
But then, as they leave the class, and then they go back to the office with the broker who's responsible, and they come up with something that, and you think, where does this come from? Well, it's a fine line. It was a course approved by the state, so you would think they believe that it is fine for our state, and that's the only thing I struggle with that.
Right, and I understand that, and I think that's been a question before about not necessarily a course on teams, but just some of the courses in general about whether that looks like the state's condoning something or the commission is, and I don't know how to answer that. If you want education broad, I think it really is kind of that determination whether you want a really broad-based education or you don't. And I think reverse mortgages has probably been a good example of that particular issue that the commission certainly has discussed over a couple of year period of time. But the one that I sent you all, that's on the list today. So, the commission can make a determination, as I say. And I think there's one other one that deals not in as much depth about teams as that one does, but that does deal with the team concept and how it's structured, so that the commission can make a determination if that's something that you want licensees educated about. Because I can see how there'd be a problem. They come back and they say, "God, we got some awesome ideas about our team," and you're like, "Oh yeah, we're not doing teams." But I think they are pretty widespread, even though they're not recognized.
The comments.
I was wondering if it would be out of whack to ask all suppliers of the material to have an affidavit saying all our material is pertinent to the state of Tennessee. It kind of puts the monkey on their back in course offering.
I don't know. I mean, I guess I don't know if they would make that statement or
because
not.
Rules change monthly.
Yeah, I don't know. They're supposed. I mean, they are under an obligation to keep the information updated and current with Tennessee law if they're teaching here. And so that's one of the things that they're obligated to do. That doesn't, mean that something wouldn't get by that somebody wouldn't be aware of. Overall, the teachers, for the most part, the instructors, they appear to have good credentials. That doesn't always mean they're going to be great instructors, but they do have good credentials. But in a classroom setting, you don't always know what happens. A lot of these are Arello. A lot of our courses now are internet, and they're Arello certified. So you feel pretty confident that there's been quite a bit of vetting about those courses that are Arello certified, and they have the the certified educator also teaching them. So, you kind of feel a little better about those, and a lot of our courses, by and large, are internet courses. The classroom courses, as you all know, are fewer and fewer, except for maybe seminars and things, where you actually just have a one-shot deal here. So, that does help to some extent. And then we do still have the paper and pencil courses that we talked about last year.
Commissioner Bloom, anything?
Well, I have an idea. I don't know if this will float or not, but the course material that you sent us, by the way, I thought was excellent. I do think that we're addressing the exact problem, though, that we need to address. So I wonder if we could say that when that course is taught here, it must include the following. And I know we don't have an education director anymore, and I wouldn't rely on them to provide that, so it has to come from.
Like similar to the disclaimer they have, or something more specific?
Here's what's going to happen. They're going to read that disclaimer, and then we don't know
what
they actually teach in class.
But we do like the core class. That could change yearly as we change that. So if they had that information, they would know what changes needed to be made.
Somehow, that's probably the best kind of material I've seen submitted.
They do an excellent job. Their other course they submitted this month also was excellent.
A lot of that doesn't apply in Tennessee, and they have this disclaimer, which may or may not mean a thing to the instructor, to be honest, because we don't have any way of monitoring that.
Right.
So I wonder if we couldn't say this is an excellent course, but when it's taught in the state of Tennessee, it must include the following.
I like that.
As part of when we tell them the course, if it is approved, when we tell them it's approved, or that we have them hand out in printed material, or how would we disseminate that to the students, or
what would be the best way to do that?
But if you're teaching an affiliate course, A and B, if there's certain things that we wanted to make sure that were in those courses, or the 30-hour follow-up class.
We have the ability to structure those courses in the, especially the course for new affiliates, in whatever the commission thinks should be included in there within the statute and the rule, which, is pretty broad. So that's, that particular class can be crafted in a fashion that the commission thinks would be most beneficial to the people coming along as affiliates who are taking particularly the course for new affiliates. The pre-licensing courses, the 60-hour course, that a lot of that is geared towards the national exam, where you're learning all the legal terms and most of the things that don't specifically apply to Tennessee. But again, the commission has a lot of flexibility in crafting those themselves.
If we could figure out the best way to disseminate that, I think that'd also be helpful to the instructors, because I'm pretty sure they don't have any intention to do that incorrectly. They just may not be educated on our rules and regulations.
Right. I think that's a good idea. I can work on some language for something that would just, as I say, I'm not sure how the best way to disseminate it would be. Sometimes that's in advertising material, but I don't think that would be probably the best for this. Maybe it would just need to be part of the handouts.
How do we tell them that their course is approved?
We send them a letter.
Well, we could send them in that letter the additional material. Your course is approved with the attachment.
Right. We just want to make sure that they attach whatever it is and hand it out to the students here. Yeah. We could do that as well. And, I think most of the schools that had the providers would they'd comply with that, particularly this particular one, because they are pretty industrious.
the past, and I'm not sure, I feel like in the past there have been some courses that you all have had concerns about that you've said, we'll bring a course back to us and we want more information on this. Could you not do that here and just lay out and say, we're declining, you know,
I'm not
approving
sure
it
that
this
I would
time?
rely on that course provider's information about how that information should be taught in the state of Tennessee.
Did they not resubmit it before you all approved it, for you all to look at before you
Well,
approved it?
That's a way to do it, I suppose.
And we don't typically look at it
I feel like you've
ourselves
done
as
that
commissioners.
before. You've said, we want more on this, and bring it back to us, and then we'll look at it again.
We're a little bit crippled without an education director. And you know, I know if Eve could hire somebody, she would today, but, you know, we need that position filled by the state of Tennessee as quickly as possible. This is very important.
Other comments? Any desire to take any action at this point, other than to take about a 10-minute break? All right, come back in 10 minutes.
We're doing
Yeah,
I ate there last week. It's
Mike
good.
Michaels and his person is here, so Miss Williams are here. You can go up there
No,
and
I
sit with
think we'll be able to get
as
in,
well.
okay.
Sorry.
you with a tie on, I don't think.
It's been a while,
Yeah,
man.
have a seat right here.
Oh, right here?
Yeah.
Hey, Mike.
Hey, how you doing?
Good. How are you?
Good.
All right, ladies and gentlemen, we're back in session. At this time, Ms. Maxwell, if you'll introduce our next agenda item.
Do you want to swear him in first? Or?
Sure. Would you all raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
This morning we have informal applicant appearance by, the applicant is Ashley, is your middle name Known? Oh, I see, okay, so it's, I couldn't tell from the thing. Ashley Williams, license number 330172. She's here with her principal broker, her prospective principal broker, Mike Nichols, license number 233466. Mike Nichols, I'm sorry. Mike Nichols is the PB of Benchmark Realty LLC, firm number 262297, located in Nashville, Tennessee. Mr. Nichols was first licensed as an affiliate broker in 1987 and was first licensed as a broker in 1990 and has been a principal broker at various times since becoming a broker. The track records reflect that the firm was first licensed, the firm Benchmark Realty LLC, was first licensed 2/6 of 2013 and currently has 95 affiliate brokers and 17 brokers. Mr. Nichols has had one complaint filed against him, which was dismissed by the Commission on 10/13 of 2011. Ms. Williams has applied for an affiliate broker license. She's passed the exam, and her TBI-FBI report revealed that on or about 9/16 of 1992, Ms. Williams was convicted in the Vista, California Superior Court of possession of a controlled substance, which appears to be a felony. The TBI-FBI report states that she received probation jail time of 3 years. We initially asked Ms. Williams to explain this conviction, which appears to be a felony because of the length of the sentence and a couple of other charges for which there were no dispositions. Ms. Williams sent in statements concerning an unrelated 1991 charge and a very brief Internet search printouts from Riverside Superior Court and from the Superior Court of California, County of San Diego, showing no selections matching your search criteria. She did not say anything further about her search criteria except the requested name searched. Ms. Williams stated that she contacted the courts and was told that they do not keep records for that long. Ms. Williams wrote a letter that the Commission received that she had had a burglary charge dismissed around 1991 stemming from an incident when she was 19 and has been involved as an owner and operator of a large California construction company for 9 years, has held a real estate license in California for the past 5 years, and performed 15 flips in the last year and a half in Tennessee with an agent representing her. She is requesting that this incident be overlooked and her Tennessee license be granted. Trek Legal Counsel and I reviewed Ms. Williams' TBI FBI report and agreed that the report indicated that Ms. Williams had apparently been convicted of a felony stemming from an incident in 1992. Since Ms. Williams did not offer proof from the court that she was not convicted of a felony, it was determined that she needed to appear before the commission and be approved in order to move forward in the licensure process. Ms. Williams states that she was a beautician at a high-end salon in California for 7 years, owned and ran a large construction company for 9 years in California, and for the last 5 years has been licensed as a real estate agent in California, and her copy of her license information was included in the packet I sent the commission earlier. And the California records do indicate that she does hold a license in a non-working status in California, which was first issued on 1/12 of 2009 and which expires on 1/11 of 2017. And I'll let her answer any other questions.
Ms. Williams, do you would you like to fill any blanks in, or there's this issue that's mentioned here by counsel and by staff about a felony that you didn't address, and if you could help us with that for starters.
Sure.
And you'll need to speak close in the microphone.
Sure. When I was 19, I had a few troubled years where I did use drugs. And when I went before the court, they did convict me of a felony for possession of drugs, and they sentenced me to either 3 years in prison or a year in drug rehab. So I went to actually a year and a half of drug rehab, and I submitted the completion form. I have that here. So I did a year and a half in drug rehab, and since that day, that was 23 years ago. When I was 19, and since that day I've never had anything but a traffic ticket, never gone back to that don't drink, don't use drugs, and been a successful businesswoman.
What about the rest of the narrative? Was it accurate? Anything you'd like to add to what Ms.
No,
Maxwell?
it seems completely accurate.
All right. We're going to hear from Mr. Nichols in a minute, but in the meantime, are there questions from members of the commission to Ms. Williams?
You're living in Tennessee now?
Yes, I've been here for 2 years.
But you still hold your California license?
About a year ago, I put it in inactive status, just because the fees are about $1,500 a year there to keep everything active. I won't be selling real estate there anymore. I'm here full time.
Do you hold a contractor's license?
No, I don't. I hire contractors to do my work.
Seems like I noticed in your package there were 2 different local addresses. There's some on Edwards Avenue. Is that the correct address?
That's the first address I lived at when I moved to Nashville. I was there for a year, and then I bought a home in Portland, and I've been in Portland for a year now.
Where is Portland?
Right under the Kentucky border.
And how close is that to the office that you're?
About it's about a 32-minute drive on a daily basis.
How many miles?
I'm just guessing, but I think it's about 26 or 27.
Other questions for Ms. Williams? Do you have a narrative on Mr. Nichols, or can we just start asking him questions? Mike, tell us about your relationship with this prospective agent, why you think she's a good fit for your company, and any other information you think would be helpful.
Well, Ashley approached Benchmark Realty to obviously place her license in our firm. She liked our business model and had a relationship, I think, with one of the agents in our Cool Springs office. I interviewed with her. She had passed all of her requirements through the Tennessee Real Estate Commission, and explained to her our structure and how we operated, and we seemed to be a good fit, so I felt comfortable with going ahead and bringing her on.
Are you the principal broker?
Yes,
for her?
for the Midtown office, yes.
So she'll be with the Midtown office?
Yes, that's
then?
correct.
And Mike, I was wondering why, excuse me, Mr. Nichols, I know him. I was wondering about someone else filled out the principal broker letter of recommendation form.
That was my office manager. I think it was my understanding that someone else besides me had to fill out the form to confirm her, and then I think I signed it because it was kind of vague exactly what the instructions were on that. So.
Okay, but what it says under the letter of recommendation, and one of the references must be from that principal broker.
I was under the impression that me being here would be the reference.
Okay.
Other questions for Mr. Nichols? questions for Ms. Williams? Chair will entertain a motion at this point.
I make a motion, we approve.
Second the motion.
A motion by Mr. Chara, seconded by Mr. McMullen, that this application to continue in real estate in Tennessee be approved. Is there discussion? Hearing none, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Congratulations, good luck.
Thank you very much.
Could I say one thing? We used to have a gentleman that was on this commission, David Flitcroft, and every time we had one of these, and I don't want to take David's place in this.
He's not here. You go
He's
ahead.
not here anymore, but I just want to say to you that he's really putting his neck on the line for you, and so really respect that and do no harm, because usually when an agent gets in trouble, the principal broker is in at least as much, if not more, of trouble. So please honor that he's doing for you.
We'll make sure that happens.
Congratulations.
Absolutely, thank you.
Thanks for coming down. Well said, Marcia. You did better than David, in my opinion.
Well, she can look at it from a broker perspective.
Okay, Eve, do you want to go back with a complaint report at this point? Is that?
Or do you want to just education, finish the
Okay, that's
education
great.
report? And so I don't know if Chris Sexton wanted to update the commission on the 1 hour rule question that.
We don't have him on the agenda, frankly, so unless.
But we have the 1 hour rule, and so when I spied him out there, I thought that. I
Okay,
think
we
that
have a
the-
commissioner asking to hear from you, Mr.
Yes.
Sexton,
I
so
think
please
the
approach the mic, identify yourself for the record. and
Thank
let's-
you. Chris Sexton with the Tennessee Association of Realtors. Last month, we spoke about the 1 hour CE, and I want to thank the commission for going above and beyond in looking at making 1 hour CE being approved for licensees in the state of Tennessee. And you guys had asked us if it could be something done legislatively, and we thought it could, and we were going to discuss it. And we had a meeting with our Government Affairs Committee, and our Board of Directors will be meeting next week, and we'll be bringing a motion to them to allow us to draft legislation and secure sponsors in both the House and the Senate to get 1 hour CE approved. We think it should be pretty easy, and we're hoping we can have this in place, pending the will of the General Assembly, to have it in place by July 1st, 2015.
So, Chris, to me, that's kind of a mixed signal, because I'd heard word that you, Government Affairs Committee, preferred us do it through rulemaking process.
Well, because of the time, we would prefer the rule process, just because we, respect your position and the way the rulemaking process goes. But because of the time system, and I know you guys got rules coming up in November, and it's been a long process. You guys have been working really hard on that, and I know November is going to be, a heavy comment period for you all. So we decided to go ahead and look at it if we could do it legislatively. If the commission does not approve, that's something we can certainly talk about, and we're happy to work with you all. But again, I want to thank you, Commissioner Bloom, for bringing it up last month, and Commissioner Alexander for even trying to see if there was some way you guys could do it quickly. And I even appreciate, Commissioner Collins for bringing forward the motion to go ahead with to start the rulemaking process also.
So let me ask the Commission, is it your sense that we ought to start the rulemaking process, or is it your sense that TAR is going to take this and go legislatively with it?
It's my sense that TAR's got it under control, and we just support them in carrying it forward.
Other comments? I'm not sure that we are in a position to support TAR, but if that's going to be the initiative, and that's what you sense the directors will vote to approve that initiative?
I do. It's been a long-standing desire for several of our people in different leadership positions, and I know there's a lot of educators out there that want to have that 1 hour CE option.
Diane, I'm sorry, Commissioner Hills.
And with me being the newest one, and I do appreciate and understand TAR's ability and grateful for them to come forward to assist us, but help me, Eve or Commissioner Chair Grease, is this been the normal way in the past for changes like this, or to go? the process?
I think historically, the trade association is occasionally on its own taken off with initiatives legislatively, statutorily. We've established over the last several years a good relationship, I think, as a body with the trade organization. And so it's a collaborative effort many times. This appears to be one as well. This commission appears to me to endorse the concept. The question is, how do we get it done? And it sounds to me like the trade association is going to take the ball and run with it. At least that's the position I hear today.
Yes, and Commissioner Hales, glad to see you got to move up to the front this month. As another example, the fingerprint rule. Mm-hmm. We worked with you all, and we knew your desire to kind of raise the bar of professionalism in this industry, and that's why you guys do your informal hearings like that and get to the bottom of what's going on.
Commissioner Collins, can you address, is this an appropriate way to do this? Commissioner Hills is looking for a little history here, and you've got it. Just want to make sure. All right, anything else, Mr. Sexton?
No, thank you very much.
Does anybody have any other questions, random or not, for Chris Sexton?
Thank you, Chris.
See you.
Thanks.
All right, back to the education report.
Okay. The next portion of the education report is the courses, the approval or the not approval of the courses. There are a couple of courses that I put for discussion, but really it was just more so that the commission would know that they're being offered. Those are on the last page, and they're offered by Smith Scholler. And they're just 2 courses that involve the proposed new rules, and they're sort of reviews and educational materials about the new rules, the proposed new rules that I guess they propose to teach between now and November or the end of November. So I just wanted to make sure that the commission knew about those. The major content of those 2 courses is actually the rules themselves. And so hopefully maybe they'll get people to come to the public hearing. But anyway, I just wanted the commission to be aware of those in case you heard that those were, and make a decision whether you all wanted to approve those courses or not, that deal with the proposed new rules about which there'll be a public hearing in November. The other courses, you've looked at the course that deals with the teams, which is listed under the first section, Council of Real Estate Specialists, Building a Team to Grow Your Business. That's the course that we discussed earlier. The other courses, I can answer any questions that the commission may have about them, but they are all, they all appear to be good, solid courses about topics that would be of benefit to our licensees. There's a veterans course about working with veterans on here that is being offered. There was a course just recently offered on working with veterans that had 494 attendees, which is probably one of the largest courses, at least I've ever heard, come through. So that must be a very, very popular topic amongst the licensees at this point. And if there are any questions, I have the courses with me as well.
Did the Building a Team to Grow Your Business, so that all look good to you?
That's the course that you all had.
Okay.
I mean, I think it's a very detailed course. It's a matter of whether the material is material that that you all, if the commission wants to have out there. I mean, I can send out a disclaimer that would just say some short sort of something that they could add into the program that's taught in Tennessee, sort of like an amendment to Tennessee's amendment to this. But it also had some. I mean, if you read through it, it also had probably some good business points as well. If you take the team concept away, it had some probably solid business information.
I can make a motion to approve the education report.
Second. Motion by Commissioner Collins, seconded by Commissioner McMullen, that the education report be approved. Is there discussion on any particular topic or
Mr. Chairman, I have a question.
Mr. Bloom.
On 1375, you raised some question about that. I am curious how would you teach about proposed rules before they're rules?
Well, that was one of the reasons why I put them on the discussion, is because I wasn't sure if the commission wanted someone teaching about the rules before they were even.
I think that's confusing.
Where they were.
Yeah.
And so, while and as I say, the course material is the rules. I mean, that the proposed rules, that's what's submitted as the course material.
I'd like to suggest we defer on that one. I mean, I don't have any problem with any of the others, but I don't know how we could approve instruction of proposed rules that this body may or may not get approved in November.
Do you know when their first class is scheduled on that?
No, they don't give us, we don't get information of when the classes are going to be unless someone's in a rush and, well, it's next month, I got to have this reviewed. We don't generally know. I can contact them and find out. I thought that they would probably do it before the hearing just because that made sense to me, but that might be incorrect.
Well, what my concern is, people leave that meeting thinking these are the new rules.
I think that could well be what would happen.
I agree.
And they could change
Right.
after the rulemaking hearing, and then that's not even the proposed rules anymore, so.
Ms. Hills.
In the past, I think this is one of the things they've gone over at the TAR convention in September, or the proposed things that are coming up. So I don't know if that's on the schedule for this year, but in the past, that's been it by Smith Schuller. I do like your idea of something, a disclaimer about the state for the CRS course.
If it's okay with you, Commissioner Collins, let's pull from your
Withdraw
motion. No, your motion is good. Let's just pull course 1375 out for further discussion.
That's fine.
And I along that same line, that CRS course 122, which talks about team structure and compensation and those kind of items, to me, until we get our rules passed, it's kind of premature itself. That's just me. So I'd like to pull that one out so we can take a separate vote on that. We'll just see how that goes.
On 122 or 121?
CRS 122.
Okay.
The other course, there are two of those the two of the under discussion courses. There are actually two courses, even though the sponsor is 1375, but it's 10 proposals you can't refuse and a review of the proposed rules, and then there's real estate teams and the proposed TREC rules. So the second one focuses on, as you can imagine, the team section, and then the other one focuses on all the rules. So you'd be talking about both of those, right? Okay, I just wanted to make sure.
I don't want to put words in your mouth, Commissioner Collins, but if we can approve the education report, pulling out the CRS class 122 to talk about it separately, course 1375, and then the second part of 1375, is that right?
It's really the sponsor's number is 1375, and
Okay.
because it's under discussion, the course itself doesn't have it doesn't have a number until it's approved, so it's just 10 proposals you can't refuse. So that's one course that's 2 hours, and then they have another 2-hour course that's real estate teams and the proposed TREC rules. So it's actually 2 courses. 1375 is the number of Smith Schuller, that's their sponsor number.
So the motion is to approve these courses with 3 exceptions at the moment. Is everybody okay with voting on that motion?
Absolutely.
Let's vote. All in favor say aye.
Aye.
Those opposed, no. That motion passes. Now, let's just take them in order. Back to CRS 122. It's my personal opinion that until the rules are passed, it's hard to teach a class about how to organize a team. Not that we're even going to recognize the team, but I would argue that that one ought to be postponed until the rules pass. So I can't make that motion as chair, but those are my thoughts.
I'll make that motion.
I'll second.
Motion by Commissioner Bloom, seconded by Commissioner DeChara. Discussion on the motion. The question's been called for. Any objection to the call? Hearing none, let's vote. All in favor, vote aye.
Aye.
Those opposed, no. The motion passes. The next course is by Provider 1375. It's titled 10 Proposals You Can't Refuse, a review of the proposed 2014 TREC rules. Is there a motion on this particular class?
I make a motion we defer those two courses until after the rulemaking hearing in November.
Second.
The motion is to defer approval of these until after the rulemaking hearing. Mr. Char, just a friendly discussion. Would you want to wait until those rules are permanent?
Absolutely.
Not just the hearing part of it, but after whatever rules are passed are permanent. Everyone on the commission understand that? So the motion is to defer two courses offered by Provider 1375 until proposed rules are finalized. Any further discussion? Let's vote. All in favor of the motion say aye.
Aye.
Opposed, no. It is unanimous. Thank you. Ms. Maxwell, that concludes the education report.
Yes, that does conclude the education report at the present time. And so, do you want to move on to the complaint report? Okay. The complaint report shows that we have a total of 220 open complaints as of 8/31. Really, it's as of the first week of September. We have 220 open complaints. We've closed in this fiscal year, which is starting 7/1 of 2014, 32 complaints with no action. None have been referred to outside agencies. 3 have been closed with a letter of warning, 21 with consent order, and no revocations thus far. So we've closed 56 cases thus far this fiscal year. If you go to the next page, it's penalty monies collected as of 8/31/2014. And our total that we collected in August was $96,300. Combined with July's total, that makes $145,140. And there's a breakdown of the monies collected. Consent orders amounted to $64,000, the civil penalties. The reinstatement fees were $31,100, and we had one person pay the E&O, and that was $1,200. So that's the breakdown of the monies that we received. And then there's a couple of charts and pie charts that show what we did. Was we used to, when we did our pie chart, we would go through the complaints and base the pie chart on what the allegations in the complaint were. But then, normally the allegations, they don't always end up being what the commission makes a decision on. And so what we did was we went through the legal report decisions for July and August and found out what actually the decisions were based on, what portions of the statute and rules, and broke those down so that we hope that would be more beneficial to the licensees so that they could actually see what rules were being cited, what statutes were being cited, and that would give everyone a better picture of exactly what the commission was determining. And so we have one pie chart that shows the violations kind of broadly based, broken down by monies, the penalty amounts that were assessed for those. And then there's another pie chart that shows that same information broken down by number so that, you can see what, so maybe you had an escrow violation and you didn't have as many, but the penalty was greater. So, that was an effort to hopefully let the licensees have a better picture of what was being decided. And those should be on your iPads, although Commissioner Franks looks like she's looking for them, or I don't know, or they're there. So if there are any questions about those, I'll be happy to answer them. Hopefully this will, as I say, be more beneficial to the licensees and really seeing what is happening as opposed to just the allegations that are made, which frequently don't end up being what really the decision is based on.
So, you have questions?
Sure.
Please.
Yes, sir. I would like to ask, I see the biggest portion of the monies collected on the violations were unlicensed. So, you know, I kind of worry sometimes when we have a lot of unlicensed people when we ask them to pay for these violations. It's amazing to me that yes, they are paying.
Were paid or the ones that were authorized?
These are consent orders authorized, right?
These
They're
were the ones that are authorized,
They're
not
authorized. Yeah, I'm
necessarily
sorry.
paid.
Yeah, they're not necessarily, none of them are, I mean, these are ones that are authorized. I'm sorry, yeah.
Okay.
That's why it says complaint decisions, penalty amounts authorized. I didn't make that clear when I said that, but yes, these are authorized.
These are ones that you all have voted to send out. It doesn't necessarily mean that they've all been accepted and sent back.
Right.
Could I ask, Eve, to me, there's a pretty notable increase in the amount of civil penalties from 2013-14 to, well, let me just say it a different way. July, August was around $60,000. Last year, July, August, this year's about $145,000.
Right.
Is that because we're just badder up here now, or what?
You had
why?
a lot, a fair, I'll just answer. It ebbs and flows from month to month, and right now we have a larger number of complaints than I would say we've had in my recent memory, at least. We had a lot more presented last month. We had almost 50. And there were a fair amount of consent orders that you all authorized in that. And, you know, I don't know how to explain it except that just the sheer number, some months there's more than others. I would say probably on my report today, there aren't as many recommended consent orders as there were last month. And all I can attribute that really to is just the sheer number and sometimes the luck of the draw of which ones have been pulled out. But I think 2 months ago, we had around 20 cases presented. I think about half of them got consent orders, which is not the typical report. But it just happened to be the complaints that you all heard that month.
Thank you.
Part of it's we're just meaner now, too. We're issuing higher penalties.
And you have chosen to increase some of the
let's
amounts.
just for the record mention that, Eve, October 1st, starting October 1st, certain penalty amounts.
For citations, that's when those increases, October the 1st. Those that were voted on in May. So those that are going out for citations will increase.
Most of them doubled, as I recall. Is that?
Yes, that's
a fair
correct.
statement? Okay. And just for the record, would you tell us what a citation is compared to a complaint?
Well, a citation, it's really given a number like a complaint, but the citation is sent out without going all the way to legal. So it would be sent out for advertising or a failure to have an escrow account when you should, not for a large escrow violation. There were 7 or 8 things that one could get a citation for. So that would just be a quicker matter. If you paid it, it would be just as I say, you would just be agreeing that you had an advertising violation and you would pay the $500, and then that would end it without it going through the entire formal process. If you didn't pay it, on the other hand, then it would then go through the complete formal process. But the citation would be sent to the person, and usually it's frequently it would result from an anonymous.
Typically, when it's advertising, it's not all advertising issues. It's typically ones of maybe signage, where it's just a picture of a sign, a more complicated advertising issue, or one that we've received a lengthy written complaint about, or something that requires, that's not as much an on its face apparent violation. That typically is routed through the typical complaint process. So it's not by any means all advertising complaints that are handled that way.
Thank you.
Are there any other questions about do y'all think this will be more beneficial to the licensees if we keep adding to this so that they can see what the commission does make determinations on?
The only comment I have to make on it is I would like to say, I know that most of the property management complaints fall under that unlicensed activity, but I would like to see something mentioned about property management so that people out there understand how much of a problem property management is when you're not licensed to do that.
Okay. That there are a lot of, and there are also the escrow security deposit issues with that. So I'll figure out some way to sort of incorporate something that maybe breaks it down yet another way that that would let people know what the type of business that individuals appear to be involved in. Maybe that would be helpful. Or I guess, or do you think putting the percentage of unlicensed activities property management?
I think just I'll leave that up to you as to how to figure it out, but I think that they need that breakdown to see how much of it is actually from the property management area.
Okay, I mean, I can figure out some way to add that so that that information is available. And so we'll build on this as the year goes on, and hopefully it'll be beneficial to the...
Is this a slide you can email to education providers, trade associations? Just
yes, I could. I mean, we could make it a slide. It's on Excel, and it's we could make it a slide. I'm sure.
I don't see where it hurts instructors to have this data.
Right. I mean, and you can see the graph actually breaks it down per little rule, and then we have what the rule is, the rule of the statute, so you don't have to go searching about for it. We have that written onto the Excel spreadsheet. It's just when we tried to make that into a pie chart, it just made the pieces too tiny, so we had to group them in larger groups. But we can send that to instructors and make sure they have that information as well.
Well, that's good information for the core class.
I think it is too. Yeah, I mean, I think, as I say, hopefully actually seeing what the authorization for consent orders are will be more helpful than just allegations. So we'll see how that works out. The next order of business is the statistics and the number of licensees. And the number of licensees that we have this month, we have active 25,025, which is an increase of 231 over last month. We have inactive of 764, which is a decrease of 420, and that decrease is the result of a glitch in RBS that caused RBS to stop expiring people who are inactive. We discovered just last week or the week before that on 12/3 of 2013, RBS quit expiring inactive licenses, and they were just continuing on in an inactive status. And so so Betsy went through and put all those people who should be in expired status, and that's what dropped this number. And IS is working on resolving what made it all of a sudden start to do that and resolving that glitch. But in the meantime, Betsy's keeping up with making sure the people get put back in the status that they should be in. But anyway, that's what caused that difference in inactive this past month. Our retired number decreased by 107, and it's at 7,556. We have 350 people in broker release, so our total is 33,695, which is a decrease from last month, which is really primarily attributable to the inactive, and then our retired individuals seem to be renewing less than they did before, and they're letting their licenses expire. Our number of licenses issued this month was 340. The largest, as usual, was affiliate brokers with 238. There were only 15 broker licenses issued this past month, and then there were 43 timeshares issued. We had 11 firms that closed or retired. So we've had about an average of 13 firms a month that have closed or retired, which is better than last year when we had 17 a month close or retire. And in 2011, we had an average of 34 a month. The total number of applications, as I say, was 340 for this month. The total number of tests that were given in August was 541, so we're averaging about 475 exams a month. We've had a lot more people who want to either reinstate their license or reactivate their license, or thought that they could reinstate or reactivate it, but it turns out that they don't have a license anymore, but who are, we've had a definite increase in individuals who want to get back into the business. And I don't know if that's because they've heard for now a year or so that business is better, or whether they just are, I don't know what they are, why they've just decided to take an interest, but we really have seen an increase in applications overall that come into our office. And as I say, then people who've had licenses that want to reactivate them. We do still see the older people who are letting their licenses who are retired expire, as you've seen that happen. We had 430 individuals who took the affiliate broker exam, and 52 take the broker exam, and 54 who took the timeshare sales person exam, and we had 5 people take the acquisition agent exam. Some months we have no one take the acquisition agent exam. So there must be activity up in the Gatlinburg area, East Tennessee, with the timeshares as far as the acquisition agents, who are the people who are on the street getting individuals to go up to the timeshares to visit the timeshare developer and the timeshare salespeople. Our percentage of non-renewal for this month, this period of time, was 16%. And our overall licenses percentage of licenses not renewed over the last 12 months is 14%. If you look at the chart that involves that, you can see we were as high as 20 and 24%. So the percentage of non-renewal has dropped back to 16. It used to stay around 12 or so it is up, but not nearly as much as it was previously. Are there any other questions about the statistics? I mean, I can answer any questions that you might have about those. Nope.
None.
Okay. Then, were there any questions about the budget, which I had sent earlier to each of you? That was the budget that ended July 31st of 2014.
Next item.
No questions about that? Okay. Just have a brief E&O update. We've had 719 revocations from E&O. 53 people are in suspension for E&O right now. And we have 19,772 people who are insured with Rice, and we hope every one of them renews their insurance before 12/31 so that they are not going to have to be placed in a suspended status.
Do you know when those notices will go out?
They usually go out in October. I got on the site yesterday, and there's nothing about the renewal. You know, it's still talking about this year and the proration that you can get for the end of the year. I'm hoping at Arello to be able to sit down with Cindy and go over things that we can do together to try to make sure that everyone knows. We've in the past sent out reminders to all of the licensees about E&O. I don't know if maybe this year it might be better if we send a letter to just the principal brokers with a list of their affiliated licensees, remind them, like we did in the newsletter, that they, under the rule, are responsible for, you know, it's a failure to supervise. They're responsible to make sure that their licensees have E&O, and they can, you know, go through the civil penalties like we did in that newsletter article, and send that to the principal brokers, as opposed to trying to send something to all of the affiliate, you know, every licensee. What is it, does the commission, I mean, I don't know what the best way to reach everybody. It's just, it's a lot of people that are insured whose insurance is going to expire on 12/31.
I'm not sure that the letter to the broker with the list of their licensees is not as effective as everything, because I think they fail to remember it's their job to make sure that they have insurance.
Right, and I think with the rule that, you know, states directly that it's a failure to supervise if affiliated licensees don't have it, and you know, they have the penalties set forth, the penalty fee set forth. I thought that might impress upon them to do that, and it might be, I don't know, I feel like it might be more bang for your buck but I'm open for suggestions, because we really don't want, you know, in the past we've had anywhere from 7,000 to 12 or 13,000 people uninsured on January the 1st. And we definitely don't want to be trying to suspend that many people on January the 1st.
Folks, for those of you who have dozed off, this is the year to renew your E&O insurance, so you need to put it in your budget now. It has to be renewed by December 31st. If it doesn't get renewed, your license will be suspended on July 1st.
January.
January 1st, yeah. That's giving them the benefit of the doubt, wasn't it?
And I think it wouldn't hurt. I think, yes, it needs to go to the principal broker, but I also think it needs to go to the individual person too, just to, to double up.
Well, they get their notice from Rice.
Oh, okay. So she doesn't need to give them a notice because they're getting it from Rice.
Like Rice will send out one
But
in
the principal broker definitely needs it.
Right. I want to. And I just don't know in the past if when we've sent a mailing to everyone, if it's been as effective. I'm not sure they all get it. I mean, frequently they'll say, well, I don't ever go into the office. So, I don't know. They might have put it in a folder, but I didn't see it.
Well, a principal broker that's not going in the office, that's your first problem. But the second problem is when they see an envelope that has Tennessee Real Estate Commission on it and they don't open it. I mean, as a principal broker, I'd be shaking in my boots when I get one. So
right.
I think it's a good idea to send it to them. What do you think?
So that, and hopefully Rice can work with us on figuring, they'll send the renewal notices out, but I have a feeling that what they'll want to do is have the deadline like at 12/10 or 12/15, as opposed to having it butt up to 12/31. Rice will have 8 or 9, maybe 10 other states that renew 12/31. So we're not the only state that they've got that's going to renew 12/31. And if you pay online, which most people do, they've got to process that payment, which sometimes can slow down the entire process as they process those payments, especially with as many other states renewing. So that's one of the things I really want to address with Cindy, is try to figure out some way that that they can get those payments through and processed fast enough so that we have a good idea of what we're looking at on 1/1.
Well, that's a very small window for you then to send out letters to the principal broker, right?
That's, that there is a small window of time for it to be done and be effective. But I do think, I'm hoping really if they realize that they've got that penalty fee, once it attaches, just like with the other licensees, once that penalty fee attaches, you can't get rid of it. The commission can't waive it. It's there, and you've got to pay it before you get your license back. But I do want to make sure that we get it out there as much as we can, and we tell people that call in, we try to remind them. But in the past we know we've done a lot of reminders, and we still have these large numbers of people that aren't insured on 1/1, and that makes it difficult since they have to go into suspended status.
Well, I think a lot of the problem is because everything else is due on 12/31, that if we could back that date up with sending them to like the 15th, that might help some.
And I think, they do that, like they'll put like a 12/10 or 12/15. They'll put a date earlier for it to be into their office so that they can process it and, get it into our system. And sometimes, and especially if you have a conformity, that takes a lot longer. They have to do each one of those by hand. So those take longer. And they're not the only ones who renew. I think that Exits is up 1/1, CRY's up 1/15. There are a couple of other, actually almost all the alternates are up 1/15. All the big alternates are up 1/1 or 1/15. So it's like we have almost everyone's up at that point in time. But Rice by far has more than anyone else has. So, so as I say, I just want to, if anyone has any ideas that they think would be better, please let us know so we can kind of get working on those, because we got to get those letters out pretty soon. And we do have it on the website, and as I say, it was in the newsletter, and hopefully you all got a copy of the newsletter and got a chance to read it. Kimberly did a great job of taking the initiative to put that together. And, we hope that the licensees will go onto the website and look at it. And, we've tried to work on the website to make it a little more user-friendly. As I say, we can only work with the middle part, but we've tried to make it a little more user-friendly and put some alert, like a tab to alerts on there. And so hopefully that'll make people go to it. And once we get our resource on there, I'm sure they'll go to it more.
I'm sorry. You brought Kimberly up. I would just like to take this opportunity to say we are so glad to have Kimberly. You are a very welcome addition to this commission, and you're doing an awesome job. Keep up the good work.
Thank you.
She does do a great job. We're glad to have her.
So I'm back on E&O just for a second. And I agree, Kimberly. I think I've already told you that privately. I wasn't out looking for, grandstand and trying to get better food.
I want everybody to recognize how important she is to us.
Is it possible to send a principal broker a letter on December 20th saying, these are the people we haven't heard from yet?
We've done that in years past. We've done, not on the 20th because it probably wouldn't get there by then, but we have done that in the past. We've normally done it after the year rolled over, after we sort of had the 12/31 rush at Rice and they had a chance to process all of those that came in. But because of the statute that requires suspension, we can't really do that. And so we would have to send it to them probably 12/1, and we have done that in the past, and we could do that again and tell them, these are the people that we don't have,
Past, do we find the principal broker as well for failure to supervise?
We have, in the past, it has been in the policy, and one year we started that process, but we had so many outstanding, like licensees, just brokers and affiliate brokers, that we didn't pursue. That was the year that we had hearings for everyone, brought them in sort of like a traffic court situation, and we'd have, 10 or 15, 20 scheduled in the morning and in the afternoon. And we ended up, that took so much time and resources that we ended up not pursuing the principal brokers. And then the next time around, there was another decision not to pursue the principal brokers with those penalties. So this is really the first time that it's actually, in a rule, and will have to be pursued because it's in a rule. So it will be a surprise to most of them. I would say probably most of the principal brokers didn't read the rules on the E&O and fingerprint that were, made effective in May. They probably just didn't think about it, and that's one of the reasons why we want to make sure that the principal brokers are aware that they've got that exposure, just because I just have a feeling that most of them have not read those particular rules.
Tell me, what is the exposure to the principal broker January 2nd?
January 1st. Well,
let's say.
Okay.
Let's say January 1st. Nobody's working on that day, but
okay.
That's why.
So the rules say, I think I have them.
I have a copy.
Julie can read it.
Do y'all have?
No, I don't. Just the principal broker portion.
You get a consent order. I'm looking in the journal. It's written in the journal.
Yes, it's in the journal. I mean, I wrote, yes. I put that in the
It's found within Rule 1260-01-.16, which is titled Lapsed Errors and Omissions Insurance. Subsection 2 of that rule specifically deals with principal brokers of licensees who fail to maintain E&O insurance. And it's a little bit lengthy, and it is available under the rules link on the Real Estate Commission's website, so people could review it in their entirety. But it basically specifically states that a principal broker shall ensure their licensees have E&O, and a failure to do so specifically constitutes a failure to supervise, which is, of course, an existing disciplinary action under your statutes. It then goes on to provide that if a PB has an affiliated licensee whose license is suspended for failure to maintain E&O insurance, there would be no penalty to the principal broker if either of two circumstances occur. One, if the affiliated licensee provides proof of insurance which complies with the required terms and conditions of coverage within 30 days of that licensee's suspension, or if the principal broker releases that affiliated licensee whose license is suspended for failure to maintain E&O insurance within the 30 days of suspension. After that 30-day period is when the potential penalties can kick in for that principal broker if one of those two occurrences do not happen. It says that, it goes on to say that if it's been more than 30 days after suspension but within 120 days after suspension, that the affiliate licensee takes care of their license, gets it back, then there would be a $200 civil penalty to the principal broker if the affiliated licensee's insurance carrier backdated the E&O coverage to indicate continuous coverage. It would be $400 to the principal broker if the insurance carrier did not backdate that coverage when it's corrected. Then if the affiliated licensee reinstates his or her license after the 120 days, the consent order to the principal broker would contain a civil penalty of $1,000. And again, that would be likely for each licensee. You know, if you had a principal broker that had 5 licensees, that could be multiplied. So it basically falls under a failure to supervise theory, and this rule just helped specifically lay that out and give them specific guidance.
Other questions related to E&O?
Cindy not send out the renewal notice sooner than she's sending them out now? Would that not help?
She can, they can send them out. You know, what kept them up like other times is when we have the RFP that's out and she's waiting for that. But the amendment, you know, to extend it's already been signed, so she could send them out at any, I assume at any time from now forward, she could send them out.
That would help.
I mean,
maybe when we go to Arillo next week, we
Right.
can talk to her about getting them out by the 1st of October, or that first week in October anyway.
I would think they'd want to spread them out amongst the states that they have anyway, you know, so they wouldn't all be going out in one big mass of mailings. But, yeah, I mean, hopefully we can sit down and talk to her about those kinds of things. Are there any other questions about the E&O? I just want to mention one other item. The privilege tax, the professional privilege tax that principal brokers pay, the $400 that's due June the 1st, we're going to get a list from, they're sending us a list, I should say, from Revenue of the principal brokers who have not paid their $400 privilege tax. Those individuals will not be able to renew their licenses. So that's something that's new that we just found out about last week, so that any individual who does not pay that $400 privilege tax, a principal broker in our industry, will not be able to renew their license. So the Revenue is, you know, it used to be they just kind of let it go and we'd write them a letter and we'd have to have a hearing. But now this is a new approach that Revenue has decided to take. So anyway, we have, we asked just before, we haven't gotten the list, but we asked Monday what they thought our number was. And it was about, I think, 337 principal brokers who will be on that list. And as I said, we don't have the list yet. We had just asked to try to get workflow worked out to figure out how many were going to be on it. So anyway, that's, you may hear people complain, you know, principal brokers complain about that, since there are 337 or so on it, pretty fair number of them.
Well, part of the problem is they did not send out statements this year.
They don't send out statements anymore. They just, it's online and you have to get it online.
You just have to remember and go online and do it, because they don't send out statements
No, they do
anymore.
not send out statements. I can't remember. I think they send them, I'm thinking they send them online. I mean, I have to pay it for my law license. I think they send them online, but I can't even remember if they sent them online or not.
I don't remember getting anything.
Well, that, I mean, yeah, and, you know, they run that list. Revenue runs a list. I mean, they don't come through us. They go directly to IS and run that list. Who's a principal broker? It's usually run around, I think, between the 1st and the 15th of May. So, you know, if you're a principal broker at that time, you are subject to the $400. Now, if it turns out that you retired or something prior to that time, then they'll usually let it go. In this instance, if you are on the list that they give us this time, you'll have to have a tax release certificate or something. You have to have a formal document from Revenue before you can be released and allowed to renew.
And what site is that? Do you know?
It's not a site. It was in Rachel Powers had sent a email about that was the procedure that was being taken. I don't know if there's a statute that.
But you said you could go online and pay it.
Oh, to go online and pay it. I think you go to Revenue and I'm guessing that you go to
The
revenue.
Trey Hargett's office, I can't remember.
I can't remember. I can't remember. I can find that out. I can't remember. I can find it out at lunch. I don't remember. I think you go to revenue and pay it, though.
I don't remember paying, do you?
Don't you think? I think it's revenue. But I can find that out at lunch.
It is
and-
through the Department of
Yeah.
Revenue, but I'm not positive if that's who the, I would assume that's who the website's set up.
Right,
for.
but I can't remember. But I'll find that out while we are at lunch and let you know. But anyway, I just wanted, in case you all hear something about that, which you might, will get a phone call.
One more question before we take a break for lunch. This pink sheet that's provided talks about civil penalties. So I was looking through the website, and I was looking at other commissions, for instance, the funeral directors. And they occasionally fine people $5,000. Is that just their prerogative to set the civil penalties where they want to, or statutorily? Are we restricted, or by rule, to a certain amount?
That what they assessed, I mean, because you can combine violation, your rule says each day of a continued violation can be multiplied, so I'm not sure if that's what they're doing.
It's just one occasion, but I didn't know whether every commission is restricted as to how much the maximum can be.
I think he wants to know if they can change the.
I believe there's a statute, it's 56-1, I think it's 308 maybe.
Don't go to any detail on it.
And I believe it sets for each violation, it's only up to 1,000, but like I said, each day of a continued violation. I mean, and it could be a single violation of failure to supervise, but yet they said it happened over 5 days and they multiplied. I'm not sure if that's what happened. And you all have that ability as well, because within your civil penalties rule, it says that, and it goes into the facts that you take into consideration when authorizing a civil penalty, the severity of the violation, things like that. So you have that authority as well. But, you know, sometimes what you want to do is be sure you have proof of the violation continuing for that number of days, which, you know, we can always get, but sometimes that might require more information. But you do have that leeway as well.
Okay, let's take an hour-and-a-half break. We'll be back here at 5 till 1.
Or close.
I saw that they were still on here, so
I just got it for discuss.
All right, let's get back in session. Ms. Maxwell, as I understand it, we really only have one agenda item left yet. Is that the legal report? I know
That's correct.
It's a long item, don't get me wrong, but I just want to make sure we're all on the same page.
That is correct.
Julie, you don't need a break this afternoon, right?
If I run out, you know, it just may be not a necessity. I should be okay for a while.
But your paralegal is here to help.
She is. This is Jenica for anybody that hasn't met her, and she's going to help me today. I'm going to start out trying to read it, but in the event that just talking for this long, I get short of breath and you're listening to me puff into the microphone, she may do the reading and I can still answer any questions you have. So.
As we get started on this legal report section, I'd like for the audience to understand where we are and how we got to this place. Somewhere along the way, someone filed a complaint, and it went eventually to the legal department, who researched the complaint, talked to the complainant, talked to the respondent. Sometimes yes. Not. And then created a report that they're about to read to us today. And it's a narrative where all indications of who the agent is, where that agent is from, or agents are from, whether they're male or female, all of that's been scrubbed. So what this commission does is listen to the report. The legal department will give us a recommendation on how to handle it, and then this commission will decide whether to accept the legal department's recommendation, discuss it a while and come up with something else, or go in a totally different direction on the particular issue, or perhaps the principal broker of the licensee. So we're about to hear for the first time, although we've been presented, Julie, and that's where I want to get to. Some of these we had earlier before today. Can you tell us where the case, which are the new cases we haven't seen before?
And people will probably be able to hear from the presentation, but just to make it clear, it's the first two matters on the report are being reread. The first matter is not being represented, but I'm including my original presentation in its entirety so that you all will remember exactly what you heard the first time. It's being represented because we got additional information since the last time that you all heard this that I felt was was substantial enough to warrant you rehearing it. You know, when someone gets a consent order, it's by no means an opportunity to just submit an argument of I think that the commission was wrong. And, you know, you all have told me in the past, we don't want to rehear it, you know, in the legal report unless there's something substantial we did not know the first time that might affect our decision. So the first two matters, only really the one is being represented to you because of the additional information. And then the third matter, the second presentation is being represented also because there was kind of substantial additional information that I felt warranted representing it to you. The rest of them are brand new matters that I don't believe you have all heard.
As far as the brand new ones, we got some new ones?
Yes.
Today?
The commission receives a draft of the legal report several days prior to the meeting so that they can all individually go ahead and read it, not discuss it or deliberate in any way, but just because there are so many on the report, you all take the opportunity to read it individually so that you have some time to think on it. There are, I believe, about maybe 10 that weren't on there when I sent it to you simply because I had a few days before the meeting, and with the sheer volume, I was trying to get more on here. So if there's one that you all don't recognize as being in the report that you previously read, and I can still answer any questions for you, but if it's something that you feel is just too complicated, you can always defer it until next month, but I included as many as I could on the presentation today.
Okay, I think we're good to go.
Okay. Any consent order authorized by the commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. The first two matters are 2014-006331, 2014-006332. This was presented at the August 2014 meeting. And this would have made sense more last month, but it was the same complainant as the previous matter.
Mr. Chairman, since we were all here last month on number 1 and number 2, I think we ought to just proceed on to page 3.
I can just read the additional information if you all would like.
Yeah, that's what I would suggest.
If that's okay.
Without objection.
Okay. Office of Legal Counsel was able to locate Respondent 2, who, as a reminder, we had not gotten a response from last time. It was believed that we had service. And it appears from conversations that Respondent 2 did not receive Trek's copy of the complaint. However, Respondent 2 admits that Respondent 2 did receive an emailed copy of the complaint from Respondent 1, but was told by Respondent 1 that it was too late to respond. Respondent 2 submitted a response stating that the complainant gave Respondent 2 consent to list the home over email and over the phone. Respondent 2 states that complainant was mailed 2 copies of the listing agreement and faxed a copy. Respondent 2 states that a phone call with complainant confirmed that the agreement was signed and faxed back to the office, and the office assistant confirmed that a fax was received, but did not confirm that it was the document. Respondent 2 admits that Respondent 2 should have followed up with the office to verify. Respondent 2 denies misleading complainant, hiding any interest in the home, or misrepresenting anything. Respondent 2 states that complainant knew everything going on at all times and agreed to Respondent 2's efforts to market the home. Respondent 2 states that Respondent 2 spoke with complainant about renting the home but continuing to be the agent and sell the property, but stated that, if rented, it would have to run through the office as a rental. Respondent 2 states that complainant requested Respondent 2 to take pictures of the home to use against a previous realtor, and Respondent 2 advised that the home was not in a bad condition except that some items in the garage had mold growing on them. Respondent 2 states that complainant's statements about Respondent 2 and children staying in the home are not correct. Respondent 2 states that Respondent 2 went above and beyond complying with complainant's request to clean the house and barn to complainant's specifications without charging complainant any money, and sometimes Respondent 2's kids came along to help. Respondent 2 further states that complainant knew that Respondent 2 brought in a fax machine and work table for customers. Respondent 2 states that nothing was done that complainant did not agree to and requests that the Commission reconsider the violations and monetary amount within the consent order, stating that they are not justified for overlooking contract paperwork being in the file at the office. The recommendation is to discuss, and specifically the reason why this was represented to you all was, like I said, we did not have a response from this respondent at the time. The person is in broker release as of the last time I checked, but definitely as of the last meeting. And we had sent a notice of the complaint by certified mail to the home address on file with the Commission, which was returned, and we were given a P.O. box, which we sent it to. I don't believe we ever got confirmation of delivery, and then the complainant contacted us and gave us an address along with an internet advertisement of where this person was supposedly working. We tried sending the complaint to that address, and someone signed for it there. So we took that to mean maybe they were working with that firm. We didn't hear anything back, assumed we had good service, and it turns out that that was a firm that this person had worked with many years ago. It was from a third-party website, and it was not correct information anymore. I received that information from the principal broker. So Jenica was actually able to locate this person. So that's why this was represented to you, because you did not have the benefit of this response the first time.
But respondent two admits that they had a copy of the complaint in time to submit a response, but they relied on the other respondent telling them that it was too late to respond.
Right, and I believe, where the statement came from is our complaint letter says that you must rescind a response within 10 days. I'm assuming, that other respondent intended well to say, well, you're beyond the 10 days now, but yes, it was apparently relied upon. The person did admit that they did get a copy of it by email. I was just representing it because our copies had not gone through. And I believe I told you at that time that I thought we had good service because I believed we did at that point.
So could we go back to the decision that this commission took last month on this issue? And the decision was to a consent order for $2,000 for failure to supervise.
It was $8,000. The $2,000 one that was authorized, that respondent has actually paid it. That was the supervision issue. And I believe a lot of what you all had issue with the principal broker about was the fact that this licensee listed a property and listed themselves as the listing agent in the MLS and did all of those type of advertising issues without having a signed listing agreement. And the principal broker admitted that it wasn't in the file and it had been overlooked. I think that was much of your issue with the principal broker. This is merely being represented with regard to that second respondent who you authorized a civil consent order with an $8,000 civil penalty for violations of 62-13-312-B4, which is misleading or untruthful advertising. 14, which is violating any provision of this chapter, which is included because of some miscellaneous provisions later. 16, which is failing to complete administrative measures, and that's specifically with regard to this person being broker released in March and still being in broker release status when you heard this last month, and I still believe currently in that. 18, which is failing to disclose to an owner the licensee's intention or true position if the licensee purchases for itself or acquires or intends to acquire any interest in property that has been listed with the office to sell. If you'll recall, there was an arrangement between this complainant and the second respondent that perhaps the second respondent was going to purchase possibly this home, and we had some documentation to that effect, and there was no personal interest disclosure included. Then 20 is improper, fraudulent, or dishonest dealings. 313A2 is the requirement that someone file a response to a complaint filed with the commission within 10 days. 403.1 is the duty owed to all parties of diligently exercising reasonable skill and care in the transaction, and 7A within that statute, which also deals with engaging in self-dealing or acting on behalf of an entity where you have a personal interest without disclosure, and Rule 1260.02, which deals with the administrative measures, again, requiring that you either retire your license or change your affiliation within 10 days of being broker released, and 1260-02-.11, subsection 1, which also deals with the personal interest issue. Like I said, this response did not have any further documentation. It is purely, this narrative is pretty close to exactly what I received. The only reason that I represented it was because, like I said, I believed we had good service last month. But it does appear, as Commissioner McMullen pointed out, that this person admits that they did get a copy and did not respond. I'm putting it on here for your discussion. You may not want to reconsider it all. I did want to make you aware of this information before a hearing.
Let's just see. Is there a motion? Last call. Is there a motion from any member of commission?
I move that we, I don't know why we're changing our decision, so
Don't make a motion then.
Okay, I move that we...
Don't make a motion.
Okay.
The chair rules that the request dies for lack of a motion. And second. So we'll stick with our previous decision. Next item.
2014-006791. This was presented at the August 2014 meeting. A complaint was opened against this respondent principal broker on a potential failure to supervise issue regarding the previous respondent broker in complaint 2014-006731, which I will call broker. While there does not appear to be a failure to supervise, respondent submitted no response to the complaint, which was sent to the firm address on file with the commission and signed for by an individual at that address. The recommendation at that time was a consent order for $1,000 for failing to respond to a complaint filed with the commission in violation of TCA sections 6213-312B14 and 6213-313A2, plus attendance by respondent at one entire regularly scheduled meeting of the commission within 180 days of respondent's execution of the consent order. At that time, the commission voted to accept the recommendation of legal counsel. Respondent contacted legal counsel upon receipt of the authorized consent order for failure to respond to the complaint. Respondent stated that respondent was under the impression that respondent had responded through the paperwork which was sent in with the response to complaint 2014-006731. Okay. Respondent states that respondent worked very hard with the broker respondent of that complaint getting the information together for the response. Respondent states that both complaint letters arrived at the firm on the same date, and a huge assumption was made by everyone that they were the same letter, and respondent's letter was just a copy to the principal broker, as is sometimes done with other TREC correspondence. Respondent asks forgiveness for not responding and states that respondent would never intentionally not respond to anything from TREC. Respondent states that respondent has been licensed for 30 years and states that this is a mistake that will never happen again. Recommendation is to discuss whether this is something you want to revisit because it was the only issue in this consent order.
Under points 1 and 2, or cases 1 and 2, didn't we already find a failure to supervise, and you said that this person has already paid the civil penalty for that?
This is a different person, and I'm sorry that I was purely copying what was in there. This was a complaint against a principal broker for failure to supervise, the one that was ahead of it at last month's meeting. I did not copy that whole summary in there because, as you can see in this summary, I said there doesn't appear to be a failure to supervise. You all agreed. It was on a set of issues where really purely the only issue and the only alleged violation in the consent order was this failure to respond. So I didn't copy the underlying complaint that went with it just because I didn't want to read you something that appeared to be unnecessary in light of what you'd already decided.
This has no connection to numbers.
No connection to 1 and 2 at all.
Okay.
I'm sorry for
That's
that
okay.
confusion. I see how you could have read it that way.
Julie, were the letters sent separately by certified mail, or were they sent in one envelope, or how was it?
It did have its own certified mailing. Let me grab a copy of this. This letter was specifically the complaint letter, the cover letter that Mr. House would have prepared when this was sent addressed to name of the principal broker, name of the firm, the address. It was sent certified mail. It appears by its own number at the top, and I have a copy of that receipt. It appears that they had separate numbers. It says in the letter, I can just read you the very first short paragraph just to,
I think the issue is, are we going to show any leniency because somebody didn't choose to respond to a particular complaint, a consent order?
Yeah, it appears
A
that
complaint.
it was.
I'm sorry, complaint.
It was, well, no, it was a, yes.
And the reason for that is because they did not open the envelope.
It was a piece of certified mail signed for them.
I know.
I think they said that they
opened it.
mistakenly believed that it, sometimes we have correspondence where the principal broker is copied on the letter. The letter would have mostly looked identical in substance, probably to the other letter, but it was specifically addressed to this respondent, and it does say a complaint has been opened against you for failure to supervise. So, like I said, I can answer any other questions. I've got the file right here, but.
Let's see if we can get a motion. Floor is open for a motion from any commissioner. Last call. Chair rules the request dies for lack of a motion. Next item, please.
So sticking by what you authorized last month, then.
Couldn't get any change.
Okay. 2014-008931, 2014-009001. An anonymous complaint was filed stating that Respondent 1, affiliate broker, Respondent 2 is principal broker, is practicing real estate unsupervised at a branch office, stating that contracts and listing agreements are initiated and stored on the premises, that buyers and sellers come and go, that closings are conducted on site, and there is no firm real estate sign posted or any managing broker, and that Respondent 1 is supervising other affiliates. Respondent submitted a joint response stating that Respondent 2 assisted a group of agents formerly affiliated with another firm, including Respondent 1, because their former principal broker suddenly released the agents without notice due to a personal family matter, and several of the affiliates transferred to Respondent 2's firm, with Respondent 2 acting as their managing broker since the time the transfer was approved by TREC. Respondents state that the dissolved former firm's rental space was vacated, but Respondent 1 was left with the rental payments and used that office as personal workspace. Respondents state that it was never, nor ever will be, the principal address for Respondent's firm. Respondent 2 states that the affiliates have not worked unsupervised, and Respondent 1 has not acted as supervisor. Respondents state that Respondent 1's personal real estate closing was conducted on the premises because the title company, owned by Respondent 2, tries to accommodate clients by closing at a location which is convenient. Respondent 2 states that Respondent 2 has no knowledge of contracts or any other documents being stored on the premises or people visiting the location. Respondent 1 states that Respondent 1 was left with the lease when the former firm dissolved, and at that time the firm sign came down and the phone number was disconnected. Respondent states that the lease was ending soon at the time of the response, but the office has not been used as a real estate office, but only for Respondent 1 and spouse's own use. Respondents state that all listing files and documents are at the firm's office. The response indicates, and respondents attach statements from other individuals, which state that the circumstances surrounding the dissolution of Respondent 1's former firm arose from very contentious personal matters, and the responses speculate that the complaint was filed by someone as a result of those personal matters in an attempt to cause harm to Respondent 1. The statements from other agents also state that Respondent 2 has been their principal broker and Respondent 1 has not provided supervision. It does not appear from the information within the file that a branch office as defined in Rule 1260-02-.03 was being operated without a license, and therefore the recommendation is to dismiss.
Okay, I
Move
have
to dismiss.
Let's get a motion on the floor. The motion by Commissioner Frank, seconded by Commissioner Collins, is to accept council's recommendation and dismiss. Mr. Chara.
Okay, I have a question just for point of clarification. That's why I wanted to get that in. Respondent 2 states that affiliates have not worked under unsupervised and Respondent 1 has not acted as supervisor. There are more than one agent working out of this location?
The anonymous complaint that was allegedly filed by some person, I don't know if it was a he or she, I believe alleged among the allegations that there was a group being supervised by this person. I don't know that they specifically said at this address. I will check.
Because in the first paragraph it says they assisted a group of agents.
Let me see.
All hearsay though, isn't it?
The respondents, the anonymous complaint says it's in separate paragraphs. The first paragraph says that Respondent 1 is practicing real estate unsupervised at this other location. Paragraph 2 says contracts and listing agreements are initiated and stored there. Paragraph 3 says buyers and sellers have been noted to come and go. Paragraph 4 says closings of real estate transactions are conducted on the premises. Paragraph 5 says there is no firm real estate sign posted, as well as no managing broker to supervise pronoun his, her activity, pointing to that Respondent 1. Then the last paragraph says Respondent 1 is supervising other affiliates associated with the firm when that respondent is only an affiliate broker themselves. So it does not particularly say that they're at that location. They appear to be, in my opinion, at least debatably separate. It's not very clear. That's all I have from this complaint.
I'm pondering, so I'm pondering that.
While you ponder, Ms. Hills.
So am I understanding this, that Respondent 2, which is a principal broker, acknowledges that closing or closings have happened at that location.
One closing on the respondent's personal property apparently occurred at this office location.
That's not a mortgage company, though? Did you not say it was?
The title company
company.
that did the closing is owned by Respondent 2, according to Respondent 2.
Is it at that location?
No, it's not at that
Oh,
location.
okay.
They just said that they sometimes will go to do some of the go to do some of the paperwork where it's convenient for the person doing the closing, is what the indication was. I can read exactly what it says, but it was for the Respondent 1's own personal property, apparently, according to my response.
Why should?
Well, it just makes me have the impression that maybe it is being operated. It was before. I'm not sure why Respondent 1 would be continuing to lease the property if he has an office somewhere else.
Because there is a lease, right?
There was an existing lease that I believe has now ended. The response came in May, and I think the statement was that the lease was ending like that month, and that the lease was, they were already locked in, so this person was just using the desk space. Said the real estate sign had come down, the phones were disconnected, but was just working from there because the person had been left on the hook for the rent for the remainder of the time.
Have we confirmed whether there's any activity still going on after that lease expired the end of that month?
No, but I believe by the time I reviewed it, the lease was already over. I mean,
Well, that's my question. So do we know if that person, I can understand going to the end of that month till the lease was out, but if they're still operating that business out of there and the lease is up, then I have a problem with that.
I don't know that.
Wasn't the narrative that the respondent was taking care of her personal or her spouse and her business in that space, but not running a real estate company out of it?
That's what the statement was. And, even in the complaint, it said there was no real estate sign up front. That was part of the complaint. So to me, it did not appear to be being advertised as a branch for members of the public. And actually, the definition of the branch office says for purposes of TCA 6213309D, which concerns branch office license, a licensee is deemed to maintain a branch if the licensee, 1, advertises the office in any manner for the purposes of attracting the public. This appears from both sides to not be the case. 2, has a mail drop at the office, which is registered with and served by the United States Postal Service, which I don't know if that's the case or not. Or 3, invites or solicits telephone calls to the office by such means as advertising or listing in a telephone directory. And we have no indication that that is the case here either.
Just not much
Do we
to
have a
go
motion?
by.
Yeah, we do have a motion. The motion offered by Commissioner Franks and seconded by Commissioner Collins was to accept council's recommendation and dismiss. Is there further discussion? All right, let's vote. If you're in favor of the motion, please vote aye.
Aye.
Those opposed, no.
No.
It appears to the chair that there are 5 ayes and 2 noes. Mr. Chara and Ms. Hills vote no.
I'm sorry. 2-0.
Wait a minute, maybe Jenica wants to do it for a while. I mean, how are you? Are you doing okay?
I'm okay for right now, but
Okay.
thank you for checking.
Okay.
2014-010-231, 2014-010-232. Complainant states that complainant purchased a timeshare from respondents. Respondent 1 is principal broker. Respondent 2 is a real estate firm, which included adding an annual week and trading back 6 timeshares.
Motion to dismiss.
Second.
So we have a motion by Commissioner Chara, seconded by Commissioner Collins to dismiss. Is there discussion on the motion?
This was one of the ones that was in the
Right.
information you got ahead of time, so.
For the audience's benefit, Mr. Chara, would you like to tell a little bit about timeshares and what we can and can't do, and why you made that motion?
We can't do anything. So it's pretty much a lame duck. They kind of just got dumped on us, and we really
Well,
can't
a lot
do
of it is,
anything.
there's a lot of these complaints outline what they allege to be verbal misrepresentations, and many times the contractual documents that were signed, unfortunately, contradict the verbal misrepresentations that are alleged to have been made. And so we have documents that were signed by these purchasers that acknowledge that the agreements contain the entire understanding. They're not relying on subsequent statements. So what she's trying to say is, it appears to be a he said, she said, and unfortunately for the complainants, the documents tend to back up what the respondents typically say in these circumstances.
And their paperwork is perfect.
Did you say yes to that, Julie?
Their paperwork is extensive. I don't know if it's perfect, but
Okay, I just wanna
typically
make
it
sure
covers most of the occurrences that come up in these complaints, and it's pretty thorough. And so,
All right, so we have a motion on the floor. Any further discussion? Thank you for the clarification. Let's vote. All in favor of the motion, vote aye.
Aye.
Those opposed, no. Motion carries unanimously.
2014-010-601, 2014-010-602. Complainants state that they purchased a lot, and Respondent 1, principal broker, is one of the 3 developers of the community. Complainants state that they were given the bylaws of the section of the subdivision and for the entire subdivision. Complainants state that the section's bylaws were not legal, as there was not a homeowners association for the section, and the section was not turned over to the entire subdivision's HOA until 2013. Complainants state that Respondent 2, affiliate broker, is under the direction of Respondent 1. Respondent 2 is affiliated with Respondent 1's firm and was one of 3 homeowners that formed a section homeowners association before the 2013 date. Complainants state that the section HOA was never recorded at the city, county, or state level, and complainants state that Respondent 2 filed for a tax ID number with the section's HOA, hired a bookkeeper to handle the accounting, set up a bank account for the section's HOA, and filed federal tax returns requested to be completed by a CPA, which complainants state was not legal because the HOA was not a legal HOA. Complainants state that the section HOA was an illegal HOA. Complainants state that they were asked to pay a quarterly fee for lawn care, water for the streets irrigation system, and for tree trimming, and Respondent 1 did not pay money into those funds in the time prior to turning over to the main section of the HOA, even though trimming was done on lots owned by Respondent 1. Complainant states that Respondent 1 did not properly supervise Respondent 2 in Respondent 2's actions in the HOA that caused complainants to have to pay 2 association fees, and that the issues of the new association were not addressed correctly. Respondents state that the restrictions and reservations for the entire subdivision were filed in the county in 2005, and pursuant to a paragraph therein, a committee of 3 homeowners was put together to manage the common irrigation system and landscaping through hiring and supervising a contractor. After selling 5 homes, Respondent 1 states that Respondent 1 turned over the management responsibilities to the homeowners, who elected a committee. Respondents state that the committee homeowners established their own unofficial homeowners association for the original purpose, and one member, the treasurer, obtained a tax ID number for the purposes of opening a bank account, but never established an actual nonprofit corporation with the state. Respondents state that the treasurer hired a CPA to prepare tax returns, not realizing it was unnecessary, and when the treasurer of the committee could no longer continue, Respondent 2 was asked to be treasurer, as Respondent 2 was a homeowner. Respondent 2 then moved the bank account to a different bank, and hired a different CPA to file the annual return, which respondents state was not required but was also not illegal. Respondents state that the restrictive covenant stated that dues were to be paid monthly, but the committee decided instead to collect quarterly. Respondents state that by May 2011, the neighborhood had grown so that the homeowners decided to hire a professional management company to address the concerns of the neighborhood. In 2013, another management company took over for the master HOA, but did not take over the part of the development in question until the second quarter of 2013. Respondents state that Respondent 1 paid all dues as homeowner, and the committee homeowners kept appropriate records and no money was mismanaged or improperly spent. Respondents further state that Respondent 2 did not represent complainants or make any representations to them as a licensee. Based on a review of all the documents, it would appear that if there is an issue, it's an issue more appropriately handled by a civil lawsuit, as it does not appear that either respondent's actions constitute violations of TREC statutes and or rules, and therefore the recommendation is to dismiss.
Motion to approve.
I think I had you first. Motion by Commissioner McMullen to accept council's recommendation to dismiss, seconded by Commissioner DeChara. Is there discussion? Let's vote. All in favor of the motion say aye.
Aye.
Those opposed, no. Motion passes unanimously.
2014-010-691, 2014-010-692, 2014010693, 2014010751. Complainants attended a timeshare presentation given by respondents. Respondent 1 is...
Motion to dismiss.
Second.
Motion by Commissioner Chara, seconded by Commissioner Collins to accept council's recommendation and dismiss this complaint. Mr. Chara, is your reasoning the same on this one as?
It is.
And this was included in the information given to you ahead of time if you all had the chance to review that.
Correct. So, is there discussion on the motion? Let's vote. All in favor of the motion say aye. Aye. Those opposed, no. Motion carries unanimously.
And I did want to ask one other thing. I'm sorry to go back to 1, 2, and 3, the ones that you all decided to stick with your original time frame. These folks, I did tell them that I would represent it and that I could not guarantee what you all would do. They're getting close to the end period of their consent order. Is it all right if I give them one additional week to decide if they want to accept the consent order, just based on the fact that they've been waiting until this point to see if it would change at all because of the representation? Or is there any kind of time period that you all would like for me to give them? I just don't want to do something that's not authorized by you all.
Want a motion for that, Julie?
It doesn't matter. If you,
I think 14 days is fine to give them an additional 14 days because they've probably been waiting for this to come back to the commission.
I just told them I didn't have any authority to do anything other than give it to you all.
Is there objection? Without objection, then.
Okay.
You got it.
Thank you. I appreciate that. No, it was without objection. I just wanted some guidance from them just to be sure. 2014-011-291. Complainants were moving from out of state, and respondent, affiliate broker, showed them homes. Complainants stated that they contracted on a home, had a home inspection, and signed a proposal to repair or replace items that did not pass inspection. Complainants state that they never received a copy of the contract signed by seller, who was an owner agent, to do any of the repairs. Complainants state that respondent had seller verbally agree to repairs, but repairs were not done, including window replacement, plumbing, and HVAC. Complainants state that they were far away in another state working with respondent by phone and email to make sure repairs were completed. Complainants state that they were told by respondent that complainants could put a hold on funds after closing until repairs were made. During the move, complainants contacted the title company to release the funds so that complainants could go ahead and move in and learn that it was not possible to hold funds and the house was theirs. Complainants feel that they were misled by respondent with regard to the repairs and state that they are now stuck with a house requiring costly repairs. Respondent states that a constant line of communication was made with complainants in an effort to make the move from out of state easier. Respondent states that respondent submitted the repair proposal form to the seller and did not receive a response for a few days. Respondent states that the seller responded within the 5-day resolution period via text message and email agreeing to make the repairs. Respondent states that one of complainant's family members conducted the walkthrough prior to closing and noted that some of the repair items still needed to be addressed. Respondent states that respondent contacted complainants to notify them of incomplete repairs and to inform them they needed to delay the closing, and the lender advised them to delay as well. A statement was included from the lender that complainants were given the option to delay, but complainants closed on the home anyway from their home state. Respondent states that seller was contacted multiple times, and respondent met with seller's contractor multiple times to check on repairs. Respondent states that seller promised to have repairs made by a certain date, but when complainants arrived in town, repairs had not been made and seller quit responding to calls, emails, and text messages. Respondent states that respondent gave the complainants contact information for seller and contractor, and complainants stated they were going to contact an attorney. Respondent regrets the repairs were not made by the seller, but respondent states that respondent did everything as respondent should have. The recommendation is to dismiss.
Is there a motion?
I guess I want to understand this a little bit better. So there were some repairs to be made and promised to be made that were not made, and we closed anyway.
Right. There was a repair, and I don't know, it might be helpful, and I don't know if you all want to do this. This is your prerogative, because this is a new matter that was not on the information that you all got before. I could go ahead and read the following complaint is the complaint against the principal broker, and the principal broker submitted a separate response that might give you a little bit more information. Would you all like to hear that one first, and then maybe we could address questions jointly? Would that maybe help a little bit?
We moving to 15 then?
Number 15. If you want me to go ahead and read it, that way it might give you some more information, and then I can do all your questions at once then.
Perfect.
2014011-321, Trek opened a complaint against respondent, principal broker, for failure to supervise respondent affiliate broker in case number 2014011-291 above, hereinafter affiliate broker. Respondent states that all affiliated agents are independent contractors and states that company policies are distributed to affiliates, an extensive mandatory orientation program is given, and many educational opportunities are provided. Respondent outlines the orientation program, educational opportunities, and listing and sales contract compliance process utilized by the firm. Respondent works full-time as a principal broker and dedicates 100% of the workday to these responsibilities and is easily accessible to agents. Respondent further states that the disclaimer notice, which was signed by complainant, states that they clearly understood the role and expertise of the broker and affiliates and are very clear in outlining the buyer's role in performing due diligence and satisfying themselves as to property condition. Respondent further states that the contract gives complainants the right to a final inspection to ensure completion of agreed-upon repairs and states that closing of the sale constitutes acceptance of the property in its condition at the time of closing, and the closing could have been delayed. Respondent further states that the firm and agents do not arrange when closing should occur or what to do with closing funds. Respondent further states that the purchase and sale agreement and supporting documents were submitted and approved by the compliance broker and respondent. Respondent states that new tar repair replacement forms were not available for use in the transaction and were not at that time part of the compliance process, but the seller, owner agent, confirmed in a phone conversation with the seller that the seller agreed to all the repair requests per the repair replacement form signed by the buyers. Respondent states that affiliate broker, mortgage officer, and title company advised complainants not to close until the repairs were completed and met their satisfaction, but complainants elected to close knowing the repairs had not been completed and verified. Respondent concludes stating that it's respondent's belief that the repairs agreed to by the seller are the seller's responsibility, that affiliate broker did not mislead the complainants, and that the firm's supervisory functions exceed Trek's guidelines, and the recommendation against that respondent was to dismiss as well. But that gives you a little bit of additional maybe information. I can still answer any questions.
Okay, so respondent 1 in number 14 was also the seller of the property?
No. Respondent 1 was the agent for the buyer, the complainants. The seller was an owner agent, not one of these respondents.
Okay. So the seller was an owner agent, but not one of these parties?
Not one of these people. And there was, in case anybody had a question, there was a personal interest disclosure executed by that person.
Was that agent also under the supervision of this broker?
Let me check the forms, because I believe it would say what firm that person was with. No, they were not with the same firm, so it would not be the same principal broker.
Julie, it says in here that the TAR repair replacement forms are not available for use. Did this happen before 14?
This happened, the transaction began at the end of January. It's my understanding that the purchases of 14, and then the TAR forms the new forms came out on 2/1. This repair replacement form was the repair proposal that these buyers signed and was given to the seller is a 2014 form, but it's dated 2/3, just 2 days later. And the way that this principal broker, because I didn't understand that, not knowing exactly the timeline of the form, so I called this principal broker to try to get more of an explanation of what that meant. And basically, that principal broker said that because of the way the forms were changed in 2014, they changed their compliance review process. Up until then, the buyer, they typically used it was a buyer, I look at this all the time, but I'm missing the word.
Repair replace addendum and
yes,
repair
he said it was changing it became actually a part of the purchase and sale agreement as of 2014. Right. So as a result, they changed their compliance review process. What he was trying to say was it was not part of his compliance review because until this year it was not incorporated as part of the purchase and sale agreement. It was done by a buyer inspection contingency removal notification, and that was not didn't used to be part of his file, but due to the changes, he now puts that in as part of the contract review.
But it also says here that agents do not arrange when closing should occur.
That was in response to the the complainant's allegation, one of the complainant's allegations, and I might have missed that in there, was that the closing was scheduled by this person at an inconvenient time. And so what that principal broker was saying is we don't demand when the closings occur. That's ultimately decided by the people. And also the allegation about holding funds prior to closing, he was also saying that's not our call. That was what that response was in response to.
All right, the chair is looking for a motion, so we can keep this discussion going if we need to.
Move to accept council's recommendation on both cases.
I have a motion by Commissioner McMullen, seconded by Commissioner Collins, that council's recommendation be accepted and this complaint be dismissed. Now, discussion.
I agree with that on 15, but on 14, there are responsibilities that an agent has, and I don't believe this agent fulfilled those responsibilities. And he's sloughing it off on a buyer and a seller who wanted to do this without their... I just think that he's liable under 14. I believe it looks to me like the broker did everything he was supposed to in 15, but...
Let's do this. Let's divide the question. We heard both of them at the same time, but let's consider each one separately. So, Commissioner McMullen, was yours that you want to...
My motion is to dismiss 2014-011321, which is number 15.
Okay, that's the broker. So we're going to skip ahead just for a minute.
I'm with you.
Okay, I just want to make sure that
saying.
everybody on the commission knows where we are. Is there a discussion on Commissioner McMullen's motion to dismiss?
With regard to the principal broker.
With regard to the principal broker. All right, I hear no discussion. Let's vote. Those in favor of the motion vote aye. Those opposed, no. Motion passes unanimously. All right, the floor is open for a motion on number 14, 2014-01129.
And I may be wrong, and it could be that this agent was doing everything they possibly could, and the person they represented said, I don't care what the lender says, I don't care what you say, I want to close anyway. And if that happened, I say we dismiss it. But that's not clear to me.
Well, and I think, I mean, these are not small items, window replacement, plumbing, and HVAC. And it said, complainants state that they were told by respondent that complainants could put a hold on funds after closing until the repairs were made. And it was, to me, it was the complainant's call on that. Because I can't imagine a closing with those big items dangling, that there wasn't some conversation with the closing attorney.
And I think that was how it was referred to in the complaint, but I think it was issues with regard to the HVAC and it said specifically the HVAC unit needs to be repaired and or replaced, not working properly is how that was worded.
I think it's mostly a misunderstanding. The complainant is saying that the respondent told them that they could hold the funds till after the closing, but the complainant signed documents to release the money.
In this case, I mean, I did want to point out, and I referenced it in the response, there is a statement that the respondent provided from the lender that references kind of that situation, and that statement might be kind of, that's the only third-party statement here that's outside of the complainant or the respondent that I have, but it basically states, it's a short paragraph. I can read you what the lender said, and just, I'm going to blank out when it's something personal. Yeah. This is, again, from the representative with the lender. These are the facts that I personally know about the closing of this file and repairs in question. This was a mail-away closing due to the buyer being in another state. When the closing package came along with a certified check, when the closing package along with a certified check were received back at title, the title company called me to tell me there was a sticky note on the check stating, "Hold check." I contacted the buyer and explained that the cashier's check could not be held. Title was required to disperse all money to seller and vendors, if applicable, on the day of closing in order for the loan to fund. I explained that at this point he was the official owner of the home and the lending process would be completed. He expressed concern about repairs that the seller had agreed to pay that had not yet been completed. The repairs in question were not shown on the appraisal and were not considered deferred maintenance. I also told the buyer that our other option was to delay closing until work had been completed, and again explained to him that if we closed that day as scheduled, that the lending process would be completed. He did not want to delay closing and chose to work with agents in regards to repairs. I personally emailed the listing agent and inquired about repairs that our buyer was questioning and asked for a status. He replied by email that he already paid the contractors to complete work and would work with buyer's agents to ensure work was completed. And it says, please contact me if you have further questions. That's the best I have.
buyer's agent didn't do their job.
What'd you say?
I believe the buyer's agent did not do their job.
Mr. Bloom, the floor is open for a motion.
Well, I would move that we not accept the recommendation to dismiss, and instead, I don't know what...
I make a motion that we find a violation of 62-13-4031 for failing to diligently exercise reasonable skill and care in providing services to all parties to the transaction.
That is what I wanted to say.
I'll second that if that wasn't a second.
Commissioner Bloom already seconded it. Motion by Commissioner McMullen, seconded by Commissioner Bloom. And the
You may
penalty
want to amend someone may want to amend the motion to specify to the punishment for
What
that.
was the civil penalty in your motion?
I did not specify one.
Oh, Mr. Bloom, did you
The
mean?
maximum is $1,000, is that right, Julie?
We'd have to reference 62-13-312-B14, which is violating any provision because there's not a specific one, but the maximum is $1,000. So.
I'd like to recommend that that be amended to add $1,000.
Is that okay with the maker?
And the reference to section
312-14.
312B14. And I'll second the motion to amend.
That's a friendly amendment to your motion, so you're still in first place. We got a $1,000 civil penalty. We've got the statute referenced correctly.
Both of them.
Both of them.
And you want a meeting attendance requirement as well?
Meeting attendance.
That'd be fine with me.
The only
yes.
other question I have, if it's appropriate at this point, is what I need to know specifically, because I'm like I said, I'm obviously reading this different than you are. I have to outline for this person the facts of how they violated by doing this. So please, if you could give me some direction as to how I need what you see as the problem here. What did they fail to do? Because I want to be sure that I'm conveying that
Number
correctly.
one, they should have instructed the buyer not to close until all the work is done, or hold out the deposit money at the closing, and they didn't do that. Those are two things that I think everybody would have done.
Well, let's say, first of all, we still only have a motion on the floor.
Okay.
So why don't we take a vote, and then,
That's fine.
then we'll explain the logic.
That's fine.
Is there other discussion before we vote? All right, the motion is a $1,000 civil penalty, attendance at a 2-day or a full commission meeting within 180 days, and you've got the references for the statute. All in favor of that motion, please vote aye.
Aye.
Those opposed, no. It passes unanimously. Now, Commissioner Collins, you're given some justification for your vote. I just want to make sure Julie gets it down because they're going to have to pass it on. But no, you want to say more about what?
Well, there's two things. I'm sure Gary had some ideas too. What were your
Okay, because I'm having trouble. You're saying that he should have told them not to close. He says he did tell them to delay.
If it was in the contract, if verbal contract or however, and he knew that when the money came that they had to close, he should have told them to hold out money for repairs until that was done. And he should have told them not to close till it was done. He didn't do any of those things because he was wanting to get his check as quick as possible.
So should have told them to hold out money.
Till the repairs were finished, or have some documentation that they would be finished at a certain time or before the money was released. Rounding about. We do this every day.
Well, I think one of the...
No, I'm just trying to make sure I have my notes clear. I'm sorry. To have documentation that repairs would be finished by a certain time. or tell them not to close, and have that in writing, because this person claims they did tell them to delay. So you're saying that should have been in writing as well?
Sure.
Okay.
Anything in real estate has to be in writing or.
I understand. No, I'm just making sure that I have it right for this.
Or it's merely conversation.
Should have
Idle
told
chatter.
them not to close in writing. Is there anything else, Commissioner Bloom, that you would like for me to include in there? Is there anything else? Because I know you had.
I'm assuming this individual negotiated the purchase of that property. And in that negotiation was these repairs have to be made for my client. And they articulated what those repairs were.
Correct.
And then that agent did not see that those repairs took place before we closed. That's part of their due diligence.
Okay.
That's part of, there's two requirements for clients that they be obedient and loyal. One of the things would be loyalty to make sure that that gets done, what you negotiated for their behalf, and not just rush in and get your commission check, which is what I think he did or she did.
So basically, kind of along the same lines as what Commissioner Collins said, those repairs that were outlined in that repair proposal that was signed by these buyers, they should have ensured that it was done before,
Right.
or gotten in writing that they had advised the client not to move forward to closing until done. I understand then. If that's all you have, I can.
I also would add the sentence about the complainant state that they were told by a respondent that complainants could put a hold on funds after closing until the repairs were made, and then they learned it was not possible to put a hold on funds.
Got it.
Is that enough, Julie?
That's great, if that's all
Okay.
you all saw. I just wanted to make sure that when I sent this to the person, I was outlining what you all saw as the issues.
Unanimous.
Okay,
Okay.
16, 17.
2014-012-651, 2014-012-652. Complainant states that complainant attended a timeshare presentation given by respondents. Respondent 1 is timeshare registration. Respondent 2 is timeshare salesperson.
Move to dismiss.
Second. Got a motion by Commissioner DeChara, seconded by Commissioner Franks, that this motion be dismissed as recommended by council. Is there discussion on the motion? I don't hear any. Let's vote. All in favor of the motion, vote aye. Those opposed, no. It's unanimous. It passes. Next item, 18.
2014-01-2921. A complaint was filed against respondent broker regarding complainant's purchase of 5 acres of land. Complainant states that respondent, who was originally the listing agent and acted as a transaction broker, stated that 1 acre of the property was in a hayfield. Complainant states that respondent told complainant that a survey had been done in 2000 and a surveyor had recently been out and found pins to a recently purchased adjoining parcel. Complainant states that complainant asked respondent if the adjacent owner of the rest of the hayfield would be willing to sell the rest to complainant, but respondent stated that a previous buyer had already asked and the owner did not want to sell. Complainant states that a few months after the closing, upon speaking to the neighbors and then having a survey done, complainant discovered that the adjacent owner owned the entire hayfield and the land that complainant purchased was actually a gully. Complainant states that complainant would not have never purchased the land with the gully because it does not meet complainant's needs, and complainants would not have paid the price. Complainant would not have paid the price complainant paid for the land. Complainant states that respondent violated the code of ethics and misrepresented the property. Complainant provided pictures of the property and survey documents provided by respondent to complainant. Complainant also provided copies of the transaction documents. Respondent states that complainant approached respondent and was interested in purchasing the subject land, and respondent provided the MLS printout, tax record sheet, and the survey. Respondent states that complainant was advised of complainant's rights to inspection, surveys, etc., which complainant waived, and an offer was submitted to the seller and the transaction closed. Respondent states that respondent met with complainant on 2 occasions after the purchase to discuss the position of the land, in which complainant was advised that respondent used tax records and survey to establish the land position. Respondent denies viewing the property with complainant or stating property lines. Respondent further states that no conversations were had with the owner of the adjacent land. Respondent further states that a surveyor located some property pins for a recent buyer to an adjacent property, but the surveyor was not paid and did not locate the entire location of the property, but only found line pins for the adjacent property. Respondent states that complainant signed all documents, including disclaimers and property disclosures. The recommendation is to dismiss.
Move to dismiss.
Second.
Motion by Commissioner Franks, seconded by Commissioner Collins, that this complaint be dismissed per council's recommendation. Discussion.
I tend to have a problem with this one. It appears that the respondent may have been practicing surveying according to what the complainant said and the documentation and pictures he was given.
Well, everyone has the right to get their own survey. I would never want to sell a piece of land without telling the buyer, you know, you can get a survey and see exactly where, you know, locate the pin so you know exactly what you're buying.
I think that when I gave them documents provided, but I think they were copies that this person handed to them, not anything that person had prepared, if that's what you were concerned with. It was an old survey from 2000 that this respondent had, I guess, from listing the property, so they gave them the documentation that they had.
Under a little bit.
Well, I know that we have agents out there all the time saying, well, looks like that property line is probably those trees over there, and they tend to let their mouths run away with them sometimes on showing where property lines are and everything.
Well, the fact is, they signed off on it, regardless.
They signed off on what they thought they were buying.
They signed off on their
what the agent told them.
They were signed off on they were advised of complainant's rights to inspection, surveys, etc., which complainant waived. I mean, all you can do is tell them what they can do. It's up to the buyer to decide for themselves what they want to do. You can't make them get a survey.
Is there further discussion? Mr. Chara, I sense you still have further discussion.
Well, you know, he asked the respondent about buying the other land, and the respondent told him that that had been discussed previously and that the seller had refused to sell it. And then in his response, he says that he never discussed anything with the landowner.
So it's he said, she said.
Yeah, it's pretty much a he said, she said.
Call for the question.
All right, there's a call for the question. Is there an objection to the call? I don't hear any. Let's vote. Those in favor of the motion to dismiss, vote aye.
Aye.
Those opposed, no.
No.
Motion passes 6 ayes and 1 no. Commissioner DeChara votes no.
Change my vote to no.
5 and 2. 2 noes.
Okay. 2014-013-241. 2014-013-242. Complainant states that Respondent 1, affiliate broker, Respondent 2 is principal broker, called complainant and stated Respondent 1 was with a property management firm and requested to verify information regarding individuals that had applied for a rental property. Complainant states that Respondent 1 asked open-ended questions regarding trustworthiness, habits, financial payments, transactional history, and character, but did not request to verify any information the applicants had supplied. Complainant states that Respondent 1 hung up quickly when asked about the line of questioning. Complainant states that Respondent 1 willfully misrepresented the purpose of the call, made a substantial and willful misrepresentation, and was engaged in conduct which constitutes improper, fraudulent, or dishonest dealing. Respondent 1 answered through an attorney, stating Respondent 1 is an agent employed with the property management firm as identified to complainant and works in the leasing sales department. Respondent 1 states that 2 applicants identified complainant as their current landlord, so Respondent 1 called to verify rental history. Respondent 1 states that Respondent 1 mistakenly had misplaced paperwork, and complainant chastised Respondent 1 for being unprepared and asked Respondent 1 to call back when paperwork was in order. Respondent 1 called complainant back and attached a copy of the questionnaire used during the phone call. Respondent 1 states that complainant became abusive in the phone call, so Respondent 1 quickly hung up the phone. Respondent 1 states that complainant called back back, but Respondent 1 did not answer, and Respondent 1 sent in a copy of the voicemail message. Respondent 1 denies allegations of improper, fraudulent, or dishonest dealings and states that it is common practice for rental property managers to contact applicants' current or previous landlords to verify rental history. Further, Respondent 1 denies the accusations of willful misrepresentation and denied questioning complainant about the applicant's trustworthiness, habits, character, or transactions. The questions included in the rental verification document supplied include start date of tenancy, amount of monthly payment, if the tenant has paid late, if the lease term was fulfilled, and if the tenant is eligible to re-sign a lease with the landlord. Respondent 2 states that the attorney's response outlines the circumstances and Respondent 1 was following policy. Respondent 2 states that the documentation clearly shows that Respondent 1 was being supervised before and after the occurrence. Respondent 2 states that it is top priority to ensure agents are trained and operate within the firm's policy at all times. The recommendation is to dismiss.
So moved. Second.
Motion by Commissioner DeChara, seconded by Commissioner Hills, that this complaint be dismissed per council recommendation. Is there discussion? So you have a copy of that voicemail message somewhere in your file?
There was not a copy in my file, but I typically do not put in a CD that I don't know where it came from or what it contains, especially because this appeared to be from the callback call, not even the subject call, and I did not think that it would necessarily reveal what happened in the original subject call. But I believe there's one in the staff's one, but it did not make it up. But like I said, I typically don't just put in a blank disc not knowing where it came from unless I'm pretty sure that it's going to be it
might be something good for Jenica to read if you ready. All right. Is there further discussion? The motion is to dismiss. All in favor, please say aye.
Aye.
Those opposed, no. Motion passes unanimously.
2014-014081. Complainant contacted Respondent broker regarding a home listed and states that Respondent stated the home was livable, needing flooring replaced and a good cleaning, and owners would take $8,000 cash. Complainant states the appraised value on a third-party website stated $28,000. Complainant states that Respondent gave complainant the contract on July 24, 2012, before seeing the home on August 7, 2012, with a closing date of August 8, 2012. Complainant states that at the showing, complainant was only allowed to see a part of the house because someone was sleeping in the home. And complainant was told by a co-owner of the home that the field next to the home was part of the property. Complainant states that the previous owners were to move out on August 10th, and when complainant arrived at the home, there was a padlock on the front door and the window, air conditioners, and refrigerator were missing. Complainant states one of the air conditioning units was returned. Complainant further states that the exterior walls are deteriorated. There is mold inside the walls. The central heat and air does not work. There are gas leaks. There is sewage buildup in the yard, and the home is infested with mice, ants, and cockroaches. Complainant later discovered that the field was not part of the purchase. Respondent states that complainant called looking for an investment under $10,000, discussed the subject property with Respondent, and placed an offer a few days later on the subject property for $8,000. Respondent states that the online ad clearly states fixer-upper. Complainant was aware that the home was not in good condition, and Respondent specifically told complainant that it needed repairs, but the extent of repairs is not known. Respondent states that when asked if it was livable, Respondent said people were living in the home currently. Respondent states that the closing went okay, but when taking possession, complainant called to say there was a padlock on the door. Respondent states that Respondent tried to call the sellers, but they did not reply. Respondent also left a message for sellers regarding the window units and refrigerator, but Respondent has not seen or heard from the sellers since closing. Respondent further states that after completing a few repairs, complainant listed the property for sale and gave Respondent the listing. Respondent states that after Respondent left the first firm, the firm that the person was affiliated with at the time, complainant withdrew the listing since Respondent was no longer located at that firm, but complainant did not ultimately list with a new firm. Respondent denies any wrongdoing. The recommendation is to dismiss.
Move to dismiss.
Second.
Motion by Commissioner Franks, seconded by Commissioner Collins, to accept council's recommendation and dismiss. Is there discussion? All right, let's vote. All in favor of the motion say aye.
Aye.
Those opposed, no. Motion passes unanimously. Let's take a 10-minute break.
A short 10. We'll call this meeting back to order. Julie, you ready?
Ready. I'm probably going to, I think, let her read for a little bit if that's okay, but I'll still have the files right here and I'll answer any questions you have.
Okay.
Hi, item 22-20140
14661, 2014014662, 2014014663. Complainants state that they submitted an offer to purchase a home listed by Respondent 3, affiliate broker. Respondent 1 is the firm, and Respondent 2 is principal broker. Complainants state that a counteroffer was signed on June 2nd, and Respondent 3 told complainant's agent that the contract was valid. Complainants state that there was an inspection period and a quick closing date set for June 13th. Complainants state that Respondent 3 contacted complainant's agent stating that 2 contracts were executed on June 2nd, and Respondent 3 had been trying to determine who had the legal contract. On June 10, complainants state that Respondent 3 told complainant's agent that complainants were not the primary contract and that Respondent 3 would like to buy complainants out of the contract. Complainants state that they canceled inspections set for June 11 and made alternate moving arrangements. Complainants state that on June 11, Respondent 3 again contacted their agent stating that Respondent 3 had settled with the other buyers and that complainants are the new primary offer, but did not furnish any documentation to confirm that complainants were the primary and only contract. Respondent 3 denies the allegations and states that Respondent 3 asked complainant's agent if they were willing to assign their contract for a fee since Respondent 3 made a mistake and unknowingly contracted with another offer received before complainant's offer. Respondent 3 states that 6 hours later, before complainant's agent responded with complainant's answer, Respondent 3 notified complainant's agent that the other party had resolved their dispute and the complainants could move forward as planned. Respondent 3 states that complainant's agent requested money and costs since complainants had spent the day making alternate arrangements, but sellers declined the change to the terms of the agreement. Respondent 3 further states that they received automatic notification later that evening that the inspection was rescheduled for June 17. Respondent 3 states that complainants were only willing to move forward if the sellers lowered their price $10,000, delayed the closing to allow time for the rescheduled inspection, and provided proof that they were the only contract, and complainants signed an amendment stating same. Respondent 3 states that the sellers responded with an Amendment A to extend the closing date to allow for rescheduling the inspection and confirming that the complainants were the only contract. Respondent 3 further states that complainants did not perform as agreed in the contract, and Respondent 3 did not ever tell them they were not under contract. Respondent 2 states that the affiliated agents are independent contractors and states that the company policies are distributed to affiliates. An extensive mandatory orientation program is given and many educational opportunities are provided. Respondent 2 outlines the orientation program, educational opportunities, and listing and sales contract compliance process utilized by the firm. Respondent 2 works full-time as principal broker and dedicates 100% of the workday to these responsibilities and is easily accessible to agents. Respondent 2 states that Respondent 3's response was reviewed and is believed to be detailed and accurate. Respondent 2 acknowledges that Respondent 3 may have unknowingly executed a contract on another offer before withdrawing the offer with complainants. Respondent 2 states that the information requested by complainants was provided to them and signed for in writing, and their claim of unethical behavior is unfounded because Respondent 3 never told complainants that they were not under contract. Respondent 2 further states that Respondent 3 sought advice of legal counsel, the firm's CEO, and Respondent 2 to determine legitimacy of 2 offers and the impact it would have on the sellers. Respondent 2 further states that a meeting was set with Respondent 3 to review in detail the steps involved in accepting and binding a real estate contract and how to work with multiple offers. Respondent 2 also required Respondent 3's attendance at a meeting regarding form review. Respondent 2 is confident that Respondent 3 now clearly understands how to steward an offer from initial receipt to final acceptance and binding. Respondent 2 outlines the firm's extensive supervisory efforts and compliance process and states that Respondent 2 did not fail to supervise Respondent 3. In light of these unusual circumstances, it is recommended that the Commission discuss.
Do I have a motion?
Yes, I believe Respondent 3 is guilty of diligently failing to exercise reasonable skill and care. He says that he unknowingly contracted with another offer received from before the complainant. How do you unknowingly sell one house 2 times?
I did call the principal broker for some clarification as to how this happened. I can summarize to you what they told me if this will help you understand it. I had the same issue. How did this happen? I'd never heard of this before in all the complaints I've looked at. What the principal broker conveyed to me when I spoke with him was that one offer came in mid-afternoon, and this respondent 3, the affiliate, was showing properties. Then the other offer came in later that afternoon. The second offer that came in was this complainant's offer, technically the second one that came in. And the second offer was accidentally accepted when there was really a prior offer.
How do you do that?
I'm just saying that I didn't understand how it happened, and to me that it seemed odd as to how this happened. I didn't know if there was something I was missing, that there was something strange that the owners did. You know, to me there was kind of a gap in the response, not really explaining why. So I just contacted and said, what happened here? And that's the information I got.
Well, the broker acknowledges later on that he didn't handle it right, and they had a special session with him telling him how to handle multiple
I understand. I was just trying to give you the additional information that I
Yeah.
got because I hadn't understood that from the response
Yeah,
either.
and I appreciate that. I think you do a great job trying to dig out all this stuff for us. But I do believe that Respondent 3 is guilty of failing to exercise reasonable skill and care in providing services to all parties in a transaction. 6213-403, number 1. I don't know if that attaches any fine or not, but if there is, I'd like to fine him.
You can note 6213-312B14, which loops to any violation in the chapter, and that's a maximum civil penalty of $1,000. The minimum.
Yeah, I'd like to add that.
Okay.
Second the motion.
Okay, I have a motion by Mr. Bloom and a second by Mr. McMullen for a $1,000 civil penalty
To Respondent 3.
to Respondent 3, and as to Respondents 1 and 2, we're okay with the dismissal on
Oh, it was a
those?
recommendation to discuss, so I actually don't have a recommendation on the
I
table.
think 2 is failure to supervise.
Okay, let's vote on, or is there any discussion on this motion?
And it's 1,000 in a meeting attendance, correct?
Yes,
Okay,
ma'am.
got it.
That's for Respondent 3.
Got it.
Any discussion? All in favor, aye?
Aye.
Opposed? Okay, that motion passes, okay.
Madam Chairperson,
Yes, sir, Commissioner Grease?
Chairwoman, I'd move that complaints against Respondent 1 and 2 be dismissed.
Do I have a second?
That was just talking.
Okay. Do I have a second? Motion fails for lack of a second. Okay, what's your pleasure?
Make a motion that with respect to Respondent 2, we find a violation of 6213-312, 15, failing to adequately supervise, and assess a civil penalty of $1,000.
Second.
Okay, and that is to Respondent 2, a motion for failure to supervise with a $1,000 penalty and.
Plus a meeting.
Plus a meeting, Austin.
Right.
Plus a meeting, that was made by Commissioner McMullen and seconded by Commissioner Bloom. Is there any discussion? All those in favor say aye.
Aye.
Opposed? Motion passes. Respondent 1.
Madam Chairperson, I'll move that we accept that we dismiss any charges against the firm.
Second.
I have a motion to dismiss against the firm, and it's made by Commissioner Grease and seconded by Commissioner McMullen. Any discussion on that motion? All those in favor, please say aye.
Aye.
Opposed? Motion passes. Did you get all that, Julie?
I've got it, sorry.
Okay.
Number 25-2014-015-161, complainants attended a timeshare presentation given by respondent timeshare registration. Complainants allege that misrepresentations were made and complainants would like contract cancellation. Complainants state that they were bused to the presentation and could not leave the long presentation. Complainants further state that
Move
they
to
were...
accept council's recommendation.
Second.
Motion to dismiss by Commissioner McMullin, seconded by Commissioner Franks. Any discussion? All those in favor say aye.
Aye.
Opposed? Next.
Number 26-2014-015-171, complaint was submitted by an attorney on behalf of timeshare purchasers who attended a timeshare presentation in another state. The complaint states that the purchasers attempted to trade 2 timeshares in Tennessee for an upgraded timeshare interest in that state.
Move to dismiss.
Second.
Motion to dismiss by Commissioner Franks, seconded by Commissioner Hill. Any discussion? All those in favor?
Aye.
Opposed? Motion passes. Next.
Number 27 and 28, 2014-015-251, 2014-015-252. Complainant states that complainant's spouse contracted with Respondent 1, affiliate broker, Respondent 2 is principal broker, to sell their home. Complainant states that complainant signed a warranty deed as seller and the property contains several items of personal property not owned by complainant's spouse. Complainant states that Respondent 1 assisted complainant's spouse with a side sales contract with the buyer regarding the personal property. Complainant states that the buyer notified complainant of a leather sofa that was included in this transaction and conveyed to the buyer, and both realtors were involved. Complainant states that complainant requested a copy of the separate contract from Respondent 1, but Respondent 1 refused. Complainant further states that a prior conversation with Respondent 1 made Respondent 1 aware that this was joint marital property. Respondent 1 submitted a response stating that Respondent 1 only represented complainant's spouse and was given instructions that complainant should not be allowed on the property and Respondent 1 should not give complainant any information as complainant had no rights to the property. Respondent 1 agrees that complainant called and stated there were items in the home that complainant considered joint marital property. Respondent 1 states that buyers asked for some personal items in the offer, and those items were removed and transferred to a personal property agreement. And all items except the sofa, recliners, and ottoman were the spouse's property, and the spouse stated that the spouse could work the situation out with complainant before closing. Respondent 1 states that shortly before closing, the spouse gave Respondent 1 an executed joint personal property and joint property sale approval regarding the sale of the joint property. Respondent 1 states that they waited at the closing for an extended period of time while buyer contacted complainant to confirm that the sofa could be included in the purchase, and complainant allowed the buyer to purchase the sofa. Respondent 1 states that the title company worked with complainant's attorney to have the HUD and warranty deed signed by complainant since the parties were still married. When complainant requested a copy of the contract documents, Respondent 1 states that Respondent 1 was instructed by Respondent 1's client, the spouse, not to give complainant any documentation. Respondent 1 sought advice from Respondent 2 and was told that since complainant was not a party to the contract, Respondent 1 could not give copies. Respondent 1 submitted a copy of the quitclaim deed and agreed order stating that the spouse must pay complainant for complainant's interest in the property and complainant would sign a quitclaim. Also submitted was an executed joint personal property agreement stating that the spouse is allowed to sell joint personal property and proceeds would be split, as well as joint property sale approval stating that the sofa with recliners and ottoman and a tractor would be sold after closing and the proceeds divided. Respondent 2 submitted a response reaffirming the information provided by Respondent 1. Respondent 2 states that when asked by Respondent 1 about giving documentation to complainant, Respondent 2 sought legal advice and received information that if complainant was not a party to the contract, then it is unlikely that Respondent 2 is required to provide complainant with a copy of the documents. Respondent 2 was advised that if copies were to be provided, permission should be granted from the spouse. Respondent 2 states that Respondent 1 acted in good faith to the spouse and acquired all documentation necessary regarding the rights to the personal property. Respondent 2 further states that buyers were made aware of the circumstances and listing and selling agent were in communication throughout the entire transaction. Respondent 2 states that Respondent 2 supervised Respondent 1 properly and provided the best information possible to Respondent 1. The recommendation is to dismiss.
Move to accept.
Do I have a second?
Second.
Motion to dismiss by Commissioner Bloom, seconded by Commissioner Hill. Do I have any discussion? All those in favor say aye.
Aye.
Opposed? Motion passes.
Number 292014015271. Complainant states that Respondent affiliate broker misrepresented complainant and siblings, yelled inappropriately, was rude to complainant's daughter who has a mental disorder, was not upfront about the sales price of the home, encouraged complainant to be secretive to other family members regarding the transaction, lied about things, and was only after the commission. Respondent states that Respondent knew complainant's siblings previously, and the sibling was trustee of their father's estate, hereinafter trustee. Respondent states that Respondent met with complainant and trustee at the subject property, made a listing presentation, and suggested improvements upon request. A listing agreement was signed to list the home as is with the family trust listed as seller, and the trustee signed in that capacity. Respondent states that 5 other offers were received within 48 hours and the trustee accepted an offer. Respondent states that an anonymous phone call was received asking if the subject property had been sold, but in the conversation it was divulged that the anonymous caller was another sibling and requested confidential information, to which Respondent stated that the trustee would have to grant permission. Respondent states that the call was immediately divulged to the trustee, who stated that the sibling was disgruntled regarding the estate and not to worry. Respondent states that the first contract fell through due to discovery of fungus, and Respondent followed the trustee's instructions, and another offer was accepted, which was a lower price. Respondent states that if Respondent was only out for commission, it would have been suggested to accept one of the higher offers. Respondent submitted a testimonial letter from the trustee commending Respondent for excellent work, which was submitted to Respondent's principal broker shortly after closing. Respondent denies all allegations, stating Respondent did not lie to the sibling but was not permitted to divulge certain information to anyone other than the client. Respondent further denies encouraging the trustee to be secretive to other family members. Respondent further denies being rude to complainant's daughter and states that Respondent has never spoken with her. Finally, Respondent denies lying about things, stating Respondent lives with a personal code of integrity, morality, and honesty. Respondent states that the only interaction with complainant was during the initial presentation, and all other communication has been with the trustee of the trust.
Move to dismiss.
Motion to dismiss by Commissioner Franks, seconded by Commissioner Collins. Do I have any discussion? All those in favor say aye.
Aye.
Opposed likewise? Motion passes.
Number 302014017781, a complaint was opened against Respondent principal broker on a potential failure to supervise issue regarding the previous
Move to
Respondent.
dismiss.
Second.
Have a motion to dismiss by Commissioner Grease, seconded by Commissioner McMullen. Any discussion? All in favor say aye.
Aye.
Opposed? Motion passes.
Number 31 and 32, 2014015291, 2014015292. Complainant, a retired licensee, states that Respondent 1, affiliate broker, Respondent 2 is principal broker, listed 2 properties pursuant to a court order regarding a divorce. Complainant states that Respondent 1 conspired with the husband to defraud the wife, and information can be obtained from an audit of the file regarding the properties. Complainant also states that Respondent 1 failed to place all property on the market, a vacant land tract. Respondent 1 submitted a response via an affidavit of the husband's attorney. The attorney states that a motion was granted to sell the marital home, which encompasses only 1 property and not 2 as alleged. The attorney states that Respondent 1 was selected to list all
He was selected to list all properties, executed a listing agreement, and an agreed upon appraiser was selected.
Sorry.
Motion
In
to
appraisal
dismiss.
to determine the list price.
Motion to dismiss.
Have a motion to dismiss by Commissioner Collins. Do I have a second?
Second.
Seconded by Commissioner Franks. Discussion?
Is this a new case today?
No, I believe this was one included on all of the materials that were submitted to you all prior. Am I mistaken? It should probably sound familiar. It should sound familiar if you've read it. I believe it was on there in the first draft that Commissioner Franks, is it? Yeah, I believe it was.
Any other discussion? All in favor?
Aye.
Opposed? Motion passes.
Yes, I believe this one was on the report that was emailed out to all of you individually on Friday, so you'd had several days to review all of this.
Number 33 and 34, 2014015311, 2014015312. Complainant states that in February 2014, Respondent 1, affiliate broker, Respondent 2 is Respondent 1's current principal broker, was going through complainants in a neighbor's mailboxes. Complainant states that Respondent 1 stated that Respondent 1 owned the home below complainant, but complainant states that another person is the owner and alleges that Respondent 1 later stated that Respondent 1 was the property manager, which could be found on Respondent 1's Facebook page. Complainant states that upon checking the website, Respondent 1 was not found as a real estate licensee. Respondent 1 denies meeting or speaking with complainant and states that complainant is the sibling of a former tenant of the property. The property was owned by a friend of Respondent 1, who was later evicted by the owner's attorney. Respondent 1 states that there is no such property management company as the complainant referenced, that Respondent 1 did not manage a property management company, and that Respondent 1 never received compensation from the owner of the property. Respondent 1 further states that at the time the alleged incident occurred, Respondent 1 had not begun attending real estate school. Respondent 1 states that Respondent 1's Facebook page was updated after Respondent 1's license was obtained to reflect the real estate firm as Respondent 1's occupation, though not stating that Respondent 1 was a realtor. Respondent 1 states that a license number was assigned, then unassigned, then reassigned due to a mix-up with another licensee, but Respondent 1 did not attempt to list or sell properties until confirmation that the license was fully vetted, stating that the first Facebook posting regarding selling property was after license approval. Office of Legal Counsel reviewed Respondent 1's licensing information in Respondent 1's Facebook page. It does not appear that Respondent 1 was practicing as an agent prior to licensure. Respondent 2 states that at the time of the alleged incident, Respondent 2 had not met Respondent 1, and Respondent 1 was not licensed until a later time. There does not appear to be a failure to supervise by Respondent 2. The recommendation is to dismiss.
Do I have a motion?
Move to dismiss.
Do I have a second?
Second.
Motion made to dismiss by Commissioner Grease, seconded by Commissioner Franks. Do I have any discussion? All in favor, say aye.
Aye.
Opposed likewise. Motion passes.
Number 35 and 36, 2014015351, 2014015352. Complainant states that Respondent 1 broker, Respondent 2 is principal broker, was hired to sell complainant's home as a short sale. Complainant states that 2 offers came in after being on the market for 2 months, and the information was sent to the mortgage lender for approval, but sat for about 10 months when Respondent 1 contacted complainant stating Respondent 1 was no longer going to handle the transaction. Complainant states that it was discovered that Respondent 1 refused to accept additional offers on the property, reporting it was under contract with a closing date or sold. Complainant believes the process should have been completed much quicker and states that Respondent 1 was trying to force the home into foreclosure, meanwhile ruining complainant's credit. Respondent 1 submitted a response stating that Respondent 1 has earned a designation of Certified Distressed Property Expert with the goal of helping homeowners avoid foreclosure. Respondent 1 attached a listing agreement with complainant. Respondent 1 states that complainant owed an amount on the property between 2 different lien holders, and because repairs were needed for unfinished projects, the property was first marketed at a lower amount. Respondent 1 states that the price was gradually reduced until an offer was received and 2 offers were presented to complainant. After inspection, a cash offer was accepted. Respondent states that over the next 10 months, the first lien holder had the property appraised 3 times, and Respondent 1 states that paperwork was resubmitted multiple times and over 55 phone calls were placed to the lien holder. Respondent 1 denies allegations that Respondent 1 did not accept or present additional offers, stating that another licensee contacted Respondent 1 multiple times, and Respondent 1 disclosed that a cash offer had been accepted, and the licensee was encouraged to submit a backup offer but never did. Respondent 1 further denies telling anyone that the short sale was expected to close in 2 weeks, stating that the time frame of a short sale is subject to lender's approval. Respondent 1 admits contacting complainant in April 2014 and stating that the first lender was being unresponsive, and Respondent 1 did not know how else to help complainant, and the listing agreement had expired. Respondent 1 suggested a deed in lieu of foreclosure as long as the second lien holder would release its lien, and encouraged complainant to contact the first lien holder about it. Respondent 1 states that Respondent 1 handled this transaction professionally and to the best of Respondent 1's ability, and unfortunately short sales are not always successful, which was disclosed to complainant at the onset. Respondent 2 states that Respondent 2 oversees Respondent 1's work, and Respondent 1 does everything by the book, but short sales are difficult transactions to pull off and usually only occur after a seller is under some sort of duress. Respondent 2 states that Respondent 1 went through the steps of a short sale with complainant, and all necessary documentation was executed, including a short sale addendum and third-party negotiator documentation, which explains that not all short sales work out. Recommendation to dismiss.
We'll have a motion.
Motion to dismiss.
Second?
Second.
Motion made by Commissioner Collins, seconded by Commissioner Hill to dismiss. Any discussion? All in favor, say aye.
Aye.
Opposed? Motion passes.
Number 372014015361. Complainant, a licensee, submitted a complaint against Respondent, affiliate broker, on behalf of complainant's grandparent, stating that the grandparent was a victim of elder abuse by the grandparent's only child, who was complainant's parent, hereinafter complainant's parent, and Respondent, a family friend. Complainant states that complainant's parent invested the grandparent's money in a development of complainant's parent and Respondent. Complainant states that complainant's parent attempted to sell the grandparent's current home and purchase a home in another city, although the grandparent was clearly about not wanting to live in that city. Complainant states that a rental agreement and purchase and sale agreement contingent on the sale of the grandparent's home were signed by Respondent as a president of an LLC, and complainant states that grandparent never knowingly signed the rental agreement or the purchase agreement and always indicated that the grandparent did not want to move. Complainant states that Respondent eventually removed the listing of the first home upon request of the grandparent, and complainant called Respondent's principal broker to request another agent, but principal broker would not speak with complainant without a power of attorney and did not assign a new agent. Complainant states that a POA was obtained and a court order was obtained voiding the contracts on the new home, with instructions from the judge to attempt to recover the earnest money. Complainant states that complainant found out from Respondent's principal broker that the earnest money had been released to the sellers of a home, and complainant states that the original earnest money check was forged. Complainant states that Respondent ignored fiduciary duties to assist someone, complainant's parent, in taking advantage of the grandparent and did not do anything to help the grandparent get earnest money back. Complainant submitted a copy of an order terminating complainant's parent's emergency conservatorship, sustaining complainant's POA, and requiring complainant's parent to produce financial documentation. Further, the order states that the complainant has authority to rescind or terminate any agreement or pending contract for the property involved with the lease purchase and is authorized to seek reimbursement of earnest money. Another order provided states in relevant part that complainant's parent testified that complainant's parent signs documentation on behalf of the grandparent with verbal permission using the grandparent's full name to differentiate between the grandparent's actual signature. Respondent states that complainant is not a blood relative of the grandparent and was not in the grandparent's life until recently. Respondent states that it was made clear to the complainant's parent by a physician that the grandparent could not live alone, but the grandparent did not want to live in an assisted living facility. Respondent states that the POA was not necessary since complainant's parent was the only child and there was no one else to designate to care for the grandparent. To respondent's knowledge, the grandparent's money was not invested in complainant's parents' real estate developments, but in stocks. Respondent states that the respondent was hired to look for a suitable home for complainant's parent, spouse, and the grandparent, stating that they needed a mother-in-law apartment and enough room in the house to house the grandparents' antiques, which was not affordable in the current city. Respondent states that a lease purchase was arranged until the grandparents' current home could be sold, and respondent states the grandparent understood that the earnest money had to be put down. Respondent states that respondent does not recall who wrote the check, but states that the check was written with the grandparents' full knowledge. Respondent further states that complainant's parent and spouse were making rental payments. Respondent states that respondent and spouse, also a licensee, went over to speak with the grandparent and have the grandparent sign the lease purchase paperwork. Respondent states that the grandparent understood what was being signed and signed the document with the aid of a magnifying glass, also expressing hope that the existing home would sell so the lease purchase would work out. Respondent states that the condo was overpriced and did not sell quickly, and since repairs needed to be made, respondent took the home off the market for a couple of months until completed. Respondent states that a few months later it was listed with complainant's firm. Respondent states that the complainant requested documents, but complainant was not their client, so respondent initially refused but eventually gave them to the complainant because there was nothing to hide. Respondent states that the respondent is saddened by the situation and states that respondent was trying to help a family friend. Office of Legal Counsel obtained a copy of the transaction file. The documentation does not appear to evidence of violation by a respondent, and the recommendation is to dismiss.
Do I hear a motion?
I move to dismiss.
Second.
Motion to dismiss by Commissioner Bloom, seconded by Commissioner Collins. Any discussion? All in favor of the motion, please say aye. Aye. Opposed? Motion passes.
Number 382014017911, a complaint was opened against respondent principal broker on a potential
Dismiss.
failure.
Second.
Motion to dismiss by Commissioner McMullen and seconded by Commissioner Grease. Any discussion on the motion? All in favor, please say aye.
Aye.
Opposed? Motion passes.
Number 39 and 40, 2014016031, 2014016032. Complainant toured a home with complainant's agent that was listed by Respondent 1, affiliate broker. Respondent 2 is Respondent 1's principal broker. Complainant states that it was discovered that the square footage was considerably less than listed. Complainant states that the MLS listing was later updated, reducing the price, stating it was reduced due to a short sale. Complainant believes that the appraisal was done on the larger square footage rather than the smaller actual square footage. Complainant states that the complainant submitted a contract on the property and is willing to pay up to the appraised value of an independent appraiser. Complainant states that Respondent 1 is not working in the best interest of the seller and the bank that is involved in the short sale. Respondent 1 states that the original price was based on seller's request, and the price was reduced because that was the bank's later approved price. Respondent 1 states that the square footage was listed according to tax records with a disclaimer in the addendum that the square footage is approximate. Respondent 1 attached an MLS listing and a property assessor's report. Respondent 1 states that the complainant's agent submitted an initial offer for much lower than listing price with a clause in special stipulations stating the buyer personally assessed the square footage as lower. Respondent 1 states that Respondent 1 contacted the bank to request that it verify the accuracy of its appraisal. Respondent 1 states that Respondent 1 received a request directly from complainant stating that complainant wanted an independent appraisal, but Respondent 1 advised complainant's agent that the bank does not accept independent valuations. Respondent 1 states that the seller rejected both of complainant's offers and another offer has not been made by complainant. Respondent 1 states that complainant's agent was contacted when the seller was approved for the short sale and notified that the seller may be willing to consider a lower offer, and the agent indicated that complainant may write another offer, but it has not been received. Respondent 1 states that another offer higher than complainant's was received and the seller signed it. Respondent 1 states that Respondent 1 works for the seller and not the bank, bank and is working in the best interest of the client in honoring seller's instructions. Respondent 2 states that the complainant indicates complainant will pay an amount equal to a future appraisal, but the firm's client is not willing to accept those terms and has not signed any offer from complainant. Respondent 2 further states that Respondent 2 does not know where complainant is getting complainant's square footage claim, and complainant's calculations do not match the county tax records. Respondent 2 states that Respondent 1 has performed duties professionally and timely, and the property has a pending contract awaiting final approval. The recommendation is to dismiss.
Do I have a motion?
So move.
Second.
Motion's been made by Commissioner McMullen, seconded by Commissioner Collins, that we dismiss. Any discussion? All those in favor, please say aye.
Aye.
Opposed? Motion passes. Number 41.
I'd like to point out while we're all here, on a short sale, the bank's in charge. You can't hold an agent for anything because they're not in control.
And short sales are not short sales.
No, they're long sales.
41 and 42.
2014016-121, 2014016-122. Complainant's parent was the seller of a property who states that buyer's agent, Respondent 1, affiliate broker, Respondent 2 is principal broker, gave the lockbox code to the buyers who gained access to the property before closing. The original closing was scheduled on February 25, 2014, and complainant states that the seller moved out and paid for a storage unit. Multiple extensions were signed and the closing was scheduled for March 31, 2014. Complainant states that Respondent 1 asked seller's agent if the buyers could move in over the preceding weekend, and the seller responded no, but allowed the buyers to put some of their belongings in the garage. Complainant states that the property did not close on March 31, but the buyers moved in unauthorized. Complainant states that upon contacting Respondent 1, it was realized that Respondent 1 gave the buyers the code to the lockbox, giving the buyers access to the home. Complainant filed a police report on April 2, 2014. Complainant does not believe that Respondent 1 is entitled to a commission because the buyers trespassed with Respondent 1's help. Complainant attached documentation including the transaction documents and emails. Included is an email from complainant to seller's agent stating in relevant part in response to the question of permission for early move-in that they can put their stuff in the garage. Respondent 1 submitted a reply stating Respondent 1 got permission from the seller through the seller's agent for the buyer to move belongings into the garage prior to closing. When the closing did not occur on March 31, Respondent 1 states that the seller discovered that someone was in the house and called seller's agent, who called Respondent 1. Respondent 1 states that Respondent 1 contacted the buyer and asked if the buyer had moved in, and the buyer confirmed this, and Respondent 1 informed the buyer that this was not the arrangement. Respondent 1 states that the police did not do anything since the seller allowed the buyer to move into the garage, which is part of the property. Respondent 1 states that the seller then said that the buyer had to pay for every day that the buyer stayed in the property. Respondent 1 states that the closing took place approximately 8 days later, and the buyer paid the seller for the time that the buyer stayed in the house. Respondent 2 states that the closing date was moved several times and documents were executed extending the closing until ultimately April 9,
Motion to
2014.
dismiss.
I have a motion to dismiss by Commissioner Collins. Do I have a second? Motion fails for lack of a second. Please continue.
Respondent 2 states that the seller verbally allowed the buyer to place things in the garage only, and the buyer moved into the home without knowledge of the seller and seller's agent or Respondent 1. Respondent 2 states that the seller, the seller's agent, and Respondent 1 spoke and resolved the issue with the buyer paying for the time spent in the home until closing. Office of Legal Counsel obtained transaction documents relating to the transaction. With regard to whether there was an agreement as to how the buyer was to gain access to the garage and how the buyer ultimately gained access to the garage to move belongings in, Respondent 2 stated that there was only verbal agreement between Respondent 1 and seller's agent to gain access to the garage, and the seller's agent gave Respondent 1 the lockbox combination to gain access to the garage. Recommendation is to dismiss.
Do I have a motion?
I'll move to accept council's recommendation and dismiss.
Second. Motion to dismiss by Commissioner Grease, seconded by Commissioner Franks. Any discussion? All in favor, say aye.
Aye.
Opposed? Motion passes. 43 and 44.
2014016-131, 2014016-132. Complainant purchased a home from Respondent 1, affiliate broker. Respondent 2 is principal broker as owner agent. After the purchase, complainant discovered moisture problems and water intrusion in the basement into the garage. Complainant states that Respondent 1 reassured that the only water intrusion was by the door and had been addressed by FEMA after a flood. Complainant further states that after the flood, drywall was replaced, but the framework was left in the walls to rot and a drainage system was installed, but it caused foundation problems, both of which complainant had to repair. Complainant states that complainant would never have bought the home if proper disclosures were made regarding the water intrusion problems or the drain system that was installed in the basement. Complainant further states that upon purchasing, complainant was not given keys that opened the front door, the drapes were missing, there was frozen food left in the freezer, the refrigerator was left filthy, and the main water valve was shut off, which almost caused the pipes to freeze while complainant was out of town. Complainant further states that the neighbors relayed that plumbers were frequently at the home, but the plumbing work was not disclosed either. Respondent 1 denies any misrepresentation in disclosures. Respondent 1 states that the only moisture problems Respondent 1 and spouse experienced in the basement were due to the flood, and they cannot speak to any problems that arose after complainant purchased the property. Respondent 1 states that the only work done to the foundation was to install a radon mitigation system requested by complainants in the inspection contingency in order to close the home. Respondent 1 states that the system's warranty states that the company was not liable for any flooding or water damage that occurs due to installation and wonders if it affected the moisture in the basement. Respondent 1 further states that after the flood, they repaired the home according to FEMA suggestions, and Respondent 1 answered complainant's questions regarding FEMA during contract negotiations. Respondent 1 further states that during the inspection, the inspector hired by complainants did not notice any foundation issues. Further, Respondent 1 did not have the drain installed and was unaware of drain lines beneath the foundation. Respondent 1 further states that a plumber replaced an old cast iron kitchen drain line with PVC and the main drain line was never replaced, so it was not disclosed. Respondent 1 further states that a water line was replaced because it was leaking water into the ground in the front yard and was disclosed properly. Regarding the keys, Respondent 1 states that complainant was given a key to every exterior door deadbolt per the disclosure. Respondent 1 states that the front door has a separate key for the doorknob, which Respondent 1 did not have a key to, and Respondent 1 apologizes if the doorknob was inadvertently locked. Regarding the drapes, Respondent 1 states that the MLS states blinds only, and the drapes were not requested in special stipulations of the contract, but were provided to complainant when complainant later asked for them. Respondent apologizes if there were items which were unintentionally left in the freezer and states that the house was cleaned when the movers were done. Respondent 1 states that they became aware that the main water was shut off and believes the movers turned it off while disconnecting the washing machine, and apologizes for the oversight. Respondent 2 states that Respondent 1 approached Respondent 2 because complainant continued to contact Respondent 1 regarding the property even after closing. Respondent 2 states that Respondent 1's spouse stated that the basement was a living area and a studio and was not moist while they lived there. Respondent 2 states that Respondent 1 gave proper disclosures regarding licensure and that they lived in the home. Respondent 2 further states that plumbing repairs upstairs and flood damage repairs were disclosed. Respondent 2 further states that radon was discovered during the inspection and complainant requested installation of a remediation system which was buried in the basement. Respondent 2 states that Respondent 1 was careful to disclose everything that continues to study contracts and understand policies and procedures. Office of the Legal Counsel reviewed the transaction documents. Per the Tennessee Residential Property Condition Disclosure, the seller marked no to being aware of any defects, malfunctions in interior walls, floors, plumbing system, basement, and foundation, among others. Further, Respondent marked yes for being aware of any past or present interior water intrusion from outside the home, standing water within the foundation and or basement, and explained further, some water did come through the garage, and basement doors up to 2 inches. No water came in through the foundation. All damage has been repaired, no issues since. The disclosure further states most of the plumbing has been replaced with PVC pipes, including the main line 2 years old. The recommendation is to dismiss.
Do I have a motion?
Move to accept council's recommendation to dismiss.
Do I have a second?
Second.
Motion made by Commissioner Bloom and seconded by Commissioner Franks to dismiss. Do I have any discussion?
So was Respondent 1 also an owner agent?
Yes.
Respondent 1 and 2 are both owner agents.
No, just Respondent 1. Respondent 2 is the principal broker. The complainant purchased a home from Respondent 1 as owner agent. I'm sorry, that's, yeah, it was the Respondent 1 and a spouse that had lived there, so you saw the spouse was mentioned.
Thank you.
Anything else? Any other discussion? All those in favor, please say aye.
Aye.
Opposed? Motion passes. That was a pretty lengthy report, but we made good time on it.
Great.
Judy, what else do you have?
I have my consent order log, which is on your iPads. I just put it on here every month. It's my tracking mechanism to track the consent orders that have been sent out. It's just got the complaint number and, you know, what you all authorized, the date it was sent out, and the date they signed for it. And it's just a way of sharing with you my way of tracking them and making sure they're moved along to litigation if people don't respond to them. So if you don't have any questions, it's just for your information to let you know that what you're authorizing is being sent out. So,
any questions for Julie? Ms. Maxwell, do you have anything else?
No, I don't have anything else. Just if you see people, encourage them if they'd like to come to the hearing on November the 5th, the public hearing on the new rules, to do that, or at least read the new rules that are posted.
Proposed.
Proposed.
New rules.
I said, yeah, I mean, yes, proposed new rules. Just so that, you know, everyone has a chance to read them and knows what's contained in those proposed rules.
What did you have under training program?
You know, Julie and I are continuing to work on the training/apprentice program that's required by statute.
That report that we have to
Right,
prepare.
and so what, at least I hope we can do in the next couple of weeks, is send you what statistical data that we need to gather to show that we have an ongoing program and what they've asked for in the statute, and send it to you all just for your review and comment.
You all, you all had stated last month that it was your direction you wanted to give us to move forward with representing in the report that our affiliate program is akin to an apprentice program, which we already have. So there's a certain set of questions we have to answer, and some of those require a good bit of statistical data, and so we're just trying to pull that information together so we can give you some proposed responses for you to review. So we should have those ready next month in October for you to look at.
Julie, just one question on these. Like there's 3 here that we made decisions on in March, and the respondent says they're not going to go along with our decision. They request a formal hearing, but there's no formal hearing set.
Actually, the one that says number 4, I know you don't have names, it's 20130222241. That was one that was set for hearing last month, and I should have taken that off there. Miss Ryan came in with you all. The person had an attorney and had proposed something. That was handled by an agreed order, so that's actually already been handled. I believe the other 2, I'm not positive. I know Miss Ryan's litigating those, but I'm not sure exactly what month they're set for, but I believe that they are calendared some point in the near future. I'm just not sure which month. It's those 2 right there. Do you by any chance know? I'm not exactly sure, but I do believe she has those on her schedule to be coming up in coming months.
Any other questions?
Let's, a couple of things. First of all, are there any commission comments or reports on our way out? Commissioner Bloom, anything?
No, sir.
Ms. Hills?
No, thank you.
Mr. Chara?
I did send out that link to our association and gave them fair notice to come to the rulemaking hearing, and I do think that a couple of them are planning on coming. So I expect a crowd.
Ms. Franks?
And our association in Williamson County sent it out, so Everybody's gotten it.
Mr. Collins?
Just want to remind everybody to look at your address and make sure it's correct, so we don't have any problems not getting information when you, in a due time. Some lady asked about it this morning, and I hope you found the answer from Eve today. Eve, who's the information go to, the broker or the agent? She asked that question.
The change of address?
Yeah.
I mean, it would ultimately go to us, is that, you can
Person.
do, right, and you can go online and change your home address, and you can send us an email or
Trek One form.
Or a Trek One form,
Trek
right.
One form, you can just.
And it's free for your home address, and it's $50 for your firm address, which has to be done obviously by the principal.
That answer your question? It's free.
For home, for your home address.
That's what she's wanting.
Oh, yeah.
Anything else, Mr. Collins? No. Mr. McMullen never has anything to say. Okay, so you guys that are going to have to sign out in a minute and pick up a certificate, it needs to be done in an orderly fashion. And Kimberly, are you handling that? So if you look at the lady, see the lady in the back holding the certificates up, not only do you have to sign, you have to pick up a certificate. So since we're an hour or two earlier than many of us thought we would be, this shouldn't be a problem. But are you going to sit there, Kimberly, and have them sign? Okay, if we can get a line going along the windows here, that would make the most sense, and then out the door. I hope you all enjoyed the meeting, travel safely, and hope we don't see you back here for a while.
Please be sure to sign out. Just can't tell